Yes. Lordship may take up item number 5.
Item number retaping
Retaping 5. But two appeals are there
against the same judgment.
against the same judgment, two appeals, because there were two petitions. One was filed earlier challenging the appointment of the appellant in the post of Secretary to the Honorable Chief Justice. That was official. Then he was regularized. Then they filed the another petition challenging that regulation. Well, what I find, the learned single judge has recorded certain findings which are totally unfounded and not in proper appreciation of the law as well as the fact. It is considered by the learned single judge that yes, the Chief Justice has the absolute power to choose and apply his discretion. Law permits that. Rules permit this. Also, fact remains that there is no specific rules laid down for recruitment to the post.
Secretary to the Chief Justice. Is it a cadre post?
Yes.
It is a cadre post in the sense this is altogether a different cadre. There is only one post. Single cadre post, if we may say. It is a single cadre post. I was in the cadre of senior judicial assistant. Then the post of protocol officer fell back. Post of protocol officer is not the normal channel of promotion from the post of senior judicial assistant. This is another. Therefore, when this post was sought to be filled up, protocol officer, which is a feeder cadre for the post of secretary to the Chief Justice. Then option was asked for because there is nothing specifically. Option was asked for the post of protocol officer and whoever has opted for, including from the grade of senior judicial assistant. And I opted for. Similarly,
That's right. Now,
others also-
the problem is with the method of recruitment in the post of secretary of
secretary to the Chief Justice.
Is it a post carries a different pay scale, etc.?
Yes,
It is equivalent to the
it is
superintendent.
equivalent to the superintendent.
Mhm.
The post carries a higher pay scale than the post of protocol officer.
And what is the mode of recruitment in that post?
Mode of recruitment is, by virtue of a resolution of the committee, that all options will be asked for, and from amongst them, firstly, for the post of protocol officer, it should be filled up, and then those who are eligible in the cadre of 2AA, 2B, and 2C. I belong to 2C. Their cases shall be considered. No interview, nothing. Their cases shall be considered, and from amongst them, whoever is found fit should be appointed. That is the procedure. And therefore, when this post was considered, because I was in the cadre of protocol officer, my case was also considered. And the requirement is, along with other
The whole list.
qualification, the LLB is a required qualification. Then, whole list of eligible candidates were placed before the Honorable Chief Justice, who are eligible for that post. And having considered everybody's case, the Honorable Chief Justice has chosen the appellant,
But appointed.
but appointed on officiating capacity. I was appointed on officiating capacity. Nearly about 2 years when I rendered service, all cases, my case was placed before the Honorable Chief Justice with a note by the registry for regular, whether it can be considered for regularization. The Honorable Chief Justice has considered all the aspects, gave a detailed reasonings in the records, and then said this can be regularized, ad hoc regime is not appropriate. Accordingly, regularization was done. And then challenge was made to that. And therefore, learned single just said, well, it is the absolute discretion of the honorable chief justice. But how was it considered? Question is procedurally regulated. The learned single just cannot interfere on the discretion applied by the chief justice unless it is found that this is totally arbitrary. Power is considered.
Yeah, that's right. But Mr. Mohanto, please tell us one thing. Insofar as choosing a person to discharge the duty of secretary is concerned, there you may be absolutely right that these are matters where it is Chief Justice's secretary, it is a sensitive
Exactly,
office.
my lord.
So therefore, there has to be some element of discretion. Nobody can ask questions, why have you selected
Yes.
him and why not? These are postings done at the pleasure of the Chief Justice.
Exactly.
Just the way in Council of Ministers, who is
Well,
included, who is not, nobody can ask questions. But then the appellant here is in a service which is governed by the service rules,
Yes.
right? If there is any benefit conferred to him in terms of pay scale, seniority, etc., that aspect of the matter will be different. That has to follow the edict of the rules. Correct?
Yes.
So assigning a posting is one thing, and promoting or regularizing in service in a particular post is another thing. While the first will obviously follow the discretion of the authority, which is the highest authority is Chief Justice, because he is the master of the entire registry, High Court
Right.
service. But insofar as promotion, recruitment, appointments are concerned, there the principles laid down in the rules will have to be followed, except in select cases where some relaxation is permissible.
Yes.
So the learned single judge has held that the appellant who was holding this substantive post of senior judicial assistant.
Well, here is a mistake committed by the learned chief. My full submission is that. Fact remains that there was no challenge to that post, my appointment,
To the protocol officer.
to the protocol officer. There was no challenge to my appointment to the post of protocol officer. But what
Right, then we'll have to, today this matter cannot be finally disposed of.
Yes.
Mr. Chaudhary.
Yes,
you
yes.
have-
I think my learned friend has till now has stated only facts. His submission is not backed by any legal reasoning. I'll give me 15 minutes time. I'll satisfy your lordship.
No, that's right, but.
My lord, with all respect, I'll submit
Mhm.
the argument, if it is to be accepted, which is being advanced on behalf of the other side, might as well we abandon Article 14 and 16, my lord. My lord, Article 229 of the Constitution does not confer any unfettered discretion on the Chief Justice. My lord, it is a power which is given to be exercised in a particular fact situation. Supposing, my lord, rules are silent, some equitable considerations are required. It is in those situations, my lord, Article 229 can be invoked, that too in a manner which is consistent with Article 14. Now, when the recruitment is governed by a set of rules framed under 309, my lord, it will be a dangerous precedent to recognize any discretion of the Chief Justice, and for that matter, any office, my lord. Here, my lord, we are concerned with some exercise done by the Chief Justice on the administrative side. We are not questioning the wisdom of the Chief Justice while rendering a judgment. So, my lord, it will be subject to same judicial scrutiny as it is being subject to by any other executive officer. Now, when the rule governs the recruitment, my lord, please come to page 79 of the paper.
Mr. Chaudhary, your arguments were well taken, but
Yes.
what we are asking is, we'll not dispose of the matter today.
Okay,
So we'll admit it
yes,
and post it for final hearing. You agree on a date to who is appearing for the
yes,
High Court?
yes.
But what is there in the rules? The rules are
Rules are silent, madam.
silent.
No.
Time has come when it cannot remain silent.
That's what.
You better advise your,
My lord has, I think that my lord takes up the matter in the administrative side. I've been
these
stating-
litigations are nothing but products of
These
the
are-
rules not being clear on many aspects.
It's not this rules.
It's time
have be
to-
ignored.
Streamline the rules.
My lord has a post of protocol officer, substantive post. in the administrative side by the committee, it was said that that post will be filled up in a.
So if you are promoting somebody to another post.
Yes.
how can his seniority-
It's not promotion.
What is
It's an
it then?
appointment.
It's an appointment
It's
on
an
what
appointment
basis?
Because this is not the post in the normal cadre of.
This appointment is on what basis? Either
The-
selection or promotion,
The
that's all.
protocol officer is based on selection.
Then if it is so, then protocol officer carries a different pay scale.
Everything.
If somebody gets into another post which is recognized by the rules,
Lordship.
how can his seniority be maintained in another
That's
category?
because there is an observation of a committee. That's the only reason. Otherwise, my submission before the honorable single judge was that for all intent and purpose, still the person holds that post. He is a member of 2C. So he can be considered. Unfortunately, the honorable single judge.
No, my lord, even the while giving officiating promotion as a protocol officer, it was clearly stated in the order, his seniority will be maintained in the cadre of senior
But
judicial
how
assistant.
is it possible? How is it possible? If you promote somebody, say for example, in say PWD,
It
promote
was
somebody,
officiating, it was not a substantive.
whatever it is.
The order itself says, my lord, it's not that we are saying. Order itself says. Then, my lord, he should have challenged it. He kept mum. When the order says it's an officiating promotion, what impelled him to assume that
Right,
it's a
so
sub-
this matter will.
It's possible hearing.
We will admit.
And most importantly, my lord, it doesn't have LLB degree. As per
That
the
power
rules,
is
it's a
there to
requirement.
budget. That power is there to
Oh.
relax. That is there. That is there. Court will see, this honorable court will
Oh, my
see
lord,
whether. this was-
whether records reveal that mind was applied and the requirement was relaxed.
We'll see, we'll see. Of course.
Definitely, laws will fix it.
Yes, mine was
Mr.
applied or
Chaudhary,
not.
you are correct
That
that
is to be seen.
discretion cannot be exercised in arbitrary manner.
Yes.
But sometimes the facts can justify some action, provided it comes within the fold of the rules.
Exactly, my lord. Lordship will find here, while place it at the time of hearing. Within the
So,
available
Can you-
available
Can you
framework.
please agree on a date in the month of February or March,
Let it be first week of March, my lord.
first week of March?
Yes.
Can you agree on a date?
Yes, sir. Any date convenient to my learned senior friend, my lord.
My lord, maybe on 9th or 10th or 9th, up to 8th, there is a holiday, as it appears, no?
No, we can have it in the first week of March.
That is 6, 7, 8.
Mr. Mahanta- Mr.
Second is a
Mahanta-
Thursday.
Mr. Mohanto wants to enjoy Holi in a more peaceful.
My lord, those are all. So
Only
therefore,
when I have also.
after that,
I go to my native.
Of course, you should go.
Then we can have it on 14th, my lord. It's a Tuesday.
Yes, 14th,
yes,
14th.
14th of March.
Yes.
yes.
Right. You produce the records.
I'll-
And what is the situation? What is the position now?
Until then, lordship will stay.
No, no, lordship will not.
No,
My
how
lord,
are you-
with all respect, I'll submit.
How are you going to benefit from that?
It's not a question of being benefited, my lord. Prima facie lordship will have to be satisfied that a case has been made out. Well, what is, my lord, other than narration of facts, my learned friend has not made
No,
any
I am-
submission
no,
on
no.
merit.
Facts are basically.
No, no, let my learned friend justify when a recruitment is governed by 309 rule, where is the question of exercising discretion?
No, that's right, Mr.
No,
Chaudhary.
Let my learned friend cite a single judgment of the Supreme Court.
My lord,
Just 1 minute.
question is
Just
there a set of rules?
just 1 minute.
My lord.
Mr. Chaudhary, we want to have a frank response from you. Regardless of the technicalities, if this order is stayed till 14th of March, is it going to cause any prejudice to your clients?
No, my lord,
Except for
not
the-
as such.
Except for a ego issue,
Yes.
that is another matter.
I'll leave it to you.
Will it, if it does, then we'll look at it
No,
differently.
my lord, anyway, my lord, I leave it to lordship.
Or is it that any promotion is going to be given?
No, my lord, he was sought to be made deputy registrar. That was of course it. That restriction must be there. my lord.
So we'll clarify no further promotion
Yes.
without the leave of
Yes.
this. All right.
That is of course their
In fact, we
presumption.
file an
I
IA.
do not know. Nothing of that sort.
In fact, we filed an IA, my lord, during the pendency of the case, whereby this honorable court put a restraint on the high court not to promote him further.
That order was passed?
Yes. By the single judge.
All right, so there are two appeals.
Do it.
Two
It
appeals.
is the same one.
Same one.
Actually, one against the in charge promotion, then the substantive regularization part.
So this one will cover both.
Yes, yes.
Subsequent
Last
one
one-
will cover everything.
Subsequent
So
will
we'll
come.
close the other one, saying that issues raised
Yes,
therein
yes.
will be considered in.
Exactly, it has committed to the second one. That
All right, you take down, heard Mr. K. Monto, learned senior counsel, assisted by Mr. S.
9 to close করবো লিখুন। 9 to close করবো।
It writ appeal 5, huh? Appearing for Mr. S. Chumma, assisted by Mr. S. Chumma, learned counsel appearing for the appellate. We have also heard.
My lord will keep that alive, my lord, because where there we have challenged even this, officiating promotion also. Let it remain, my lord.
No, we'll say that the issues raised in this writ petition, including challenge made to his officiating promotion,
Or can be
shall be
agitated.
examined in this
Yes.
proceeding.
Okay, then it's okay.
Mr. K. N. Chaudhary, learned senior counsel, assisted by Mr. J. Patwari, appearing for the respondent numbers.
One second. 1 to 820 niki? Right? 20, 1 to 20.
Respondent numbers 1 to 20. Mr. U.K. Nair, learned senior counsel, assisted by who's with you, Mr. Nair?
Miss Demo.
Huh?
Miss Demo.
Ms.
D.
D. Monto has appeared for the respondent numbers 21 to 24. Full stop. This appeal is directed against the common judgment and order dated 5/1/2023 passed by the learned single judge in WPC numbers 1376/2019 and
3845.
3845 of 2021. Inter alia holding that the officiating promotion given to the appellant in the post of protocol officer and the subsequent order the post of secretary to the
Chief Justice.
Chief Justice of the Guwahati High Court and the subsequent order regularizing his services in the said post is illegal. Stop. We have perused the impugned judgment and have also considered the submissions advanced by learned counsel for both the sides. Admit this appeal. Since Mr. Patwari has accepted notice, issue notice returnable on 14 March 2023. Since Mr. Patwari has appeared and accepted notice on behalf of respondent numbers 1 to 19
20.
and 1 to 20 and Ms. D. Monto for respondent numbers 21 to 24. Service of notice is deemed to be complete in this case. The learned standing counsel Guwahati High Court to produce the relevant records on the next date fixed, facilitating disposal of the writ appeal at this stage of admission hearing. Facilitating disposal of the writ appeal. You're right. That's all in this. And in the next matter, you're right. This appeal arises out of the common judgment and order dated so and so, passed in so and so, so and so. It appears that the issues raised in this appeal are substantively covered in the connected appeal being writ appeal number 5/2023 arising out of the same judgment. Mr. Chaudhary submits that in the other appeal, the question of validity of the order of regularization of the service of the other matter regularization is there.
Yes.
Service of the appellant in the post of secretary to the Chief Justice of the Guwahati High Court. Honorable Chief Justice to the Guwahati High Court is under challenge. Full stop. However, we find that the said issue also forms a part of the contentious issues arising in writ appeal number 5/2023. Full stop. As such, by giving liberty to all the parties to raise the aforesaid issue at the time of hearing of writ appeal number 5 of 2023 and without prejudice to the rights and contentions of either party to urge any plea raised in the present appeal, we close this matter.
Meanwhile, Lordship will stay the.
In the other matter, you heard on the prayer, heard on the prayer of ensuing relief. having regard to the facts and circumstances of the case. As an interim measure, we direct that operation of the, that is in para 41, is it?
Para 41.
Operation of the interim judgment and order dated so and so, more particularly, the directions passed in para 41 shall remain stayed until further orders. It is, however, made clear that no further promotion shall be given to the appellant without obtaining the leave of this court.
Well, let it be till that date, my. Till 14. There is a purpose. my lord.
Since admitted, my
Let
lord.
it be,
Mr. Chaudhary, we'll finish it off.
Yes.
let it be till 14, my lord. They're protected.
This matter is not going elsewhere.
Exactly.
So we'll finish it off. When we say we'll finish it off, we'll finish
So,
it
my
off.
lord, at times, my lord, till works.
No.
Until further sometimes makes us very complacent.
Mr. Chaudhary, both sides will be very well known to you. So let us have a balance. But these matters should be threshed out. And
Yes.
Mr. Nayak, see, the rules, a time has come when you must convey this
I have already,
observation of the court.
I have already.
That
I'm doing
if
it.
you do not streamline the rules, 67 was a long time back. Many of us maybe were
Many
not
amendments
involved.
have been made in the meantime.
No, amendments are different things.
Yes. So
As
far
a-
this aspect is concerned, there is no.
In the meantime,
Only
this,
resolution of a committee, administrative side.
perhaps you need to have a look at whether the rules need a whole hog reconsideration.
Lordship, it may-
Because otherwise, this kind of, litigations will
Situations
keep
will
cropping.
definitely arise.
And we will spend hours and hours fine tuning and going into the finer aspects of law. But why should these problems happen in a court? The clear rules are there. This is a court of law. We decide matters for others. We are being called upon to get into an issue like this. Whichever party wins or loses,
That's a different thing.
it will be a,
My lord,
It's a very bad thing.
before the 2-3 days before the hearing, my junior may be permitted to go through the records, my lord, to go through that committee's decision, because that we are not aware of. That, my lord, in presence of the junior,
Honorable Chief Justice opinion is quoted in the judgment.
no, some record. No, just 2-3 days before the hearing,
opinion in which.
let there be not in the order, my lord, with the understanding, we should be permitted some inspection,
It's
limited
there.
inspection.
Opinion with regard to what?
No, that relaxation that was.
Huh.
Now regarding the regulation, no. Regulation order was quoted.
The order was quoted in page 163.
No, that is in 172.
72.
172.
172, man.
170.
Entire order has been reproduced here.
Up to 172.
So it is there already,
Yes.
on record, Mr. Chaudhary.
It is already there.
Honorable Chief-
Anyway, if on that day, if you want.
Yes, yes, they can.
There are caveats.
Caveats may be
Caveat
discharged.
shall be discharged. That would Mr. Patwari appearing on the strength of a caveat, upper other items, no? Caveat stands discharged. All right?
giving us the reserved benefit of accelerated promotion and consequential has been overruled. The same offending clause which was struck down has been brought in another OM passed on the 18th. Well, this is too serious.
Who has issued the OM?
The Department of Personnel. Well, we cannot allow the government to take over judicial finality. Finality is always with the judiciary. And this is a very serious matter. I pray your lordship, it's already filed. We have informed the council last night. Copies are there. Everything is there.
We'll take it up tomorrow as a listed item.
Please. Can it be at 2 o'clock?
Tomorrow.
No, can it be at 2?
Today not possible. Tomorrow.
Because there are consequential orders they are going to.
Tomorrow we'll see.
Oblige.
I beg to mention item 61, my lord. Some small accommodation, my lord. Due to some personal difficulty, my lord, I could not prepare the brief, my lord.
Item number 61.
My lord.
Yes, what do you want?
Small adjournment, my lord.
On the request of Mr. Ayat Sekar, learned counsel for the petitioner made with the consent of the other side. Hearing of these matters stands adjourned for 2 weeks. Please take accordingly. Yes.
Oblige.
May please your lordship. Not the family pension matter, in spite of being ordered not listed, maybe first week of February.
Make this one. Item number 16,
Hmm.
I believe in 2 places, the age of the petitioner has been left blank. In the affidavit, it's there.
But in the synopsis, it's black.
It's blank. I was not the filing counsel, I informed.
Hmm.
I was also either my lord may allow
Let's
me,
see, let the matter be called up, then we'll see.
that difficulty is there. I second.
May please your lordship. Lordship, I pray for listing of a matter for hearing on the second day of February, my lord, if possible, my lord.
What
Yeah.
matter?
Here I am challenging the order passed by the Director Technical, my lord, by which I have been imposed the penalty of removal from service, my lord. 2016, my lord, pleadings are already completed. Kind of blessing.
My lord, I beg to mention for listing of an IM, my lord, for vacating of stay order, my lord, regarding transfer case, my lord. It was my lord, on the vacation, my lord, 28, it was stayed. And we have filed the IA on the 10th of January, my lord.
When do you want it?
Wednesday, my lord, if possible, or Friday, my lord.
All right,
Friday, my lord.
yes.
May I please? My lord, item number 7, I may be allowed to withdraw with liberty to file a fresh one.
Why you want to withdraw?
My lord, a consequential order I could not annex one. That needs to be challenged.
All right, Mr. Bhattacharya, learned counsel for the petitioners submits that there has been some subsequent developments connected with this writ petition, and therefore he be granted leave to withdraw the writ petition with liberty to file afresh by incorporating all relevant documents. Since the prayer is not opposed, same stands allowed. Writ petition stands disposed of on withdrawal with liberty as paid for.
May I please, your lordship, may I pray for listing of a matter for motion, lordship? Can it be on Friday, my lord? Oblige, your lordship.
May it please your lordship, with the consent of the other side, my lord, I beg to mention item number 28, my lord. May pass over for a day, my lord.
28.
28, taken the consent, my lord.
All right, on the request of Mr. Mishra, R.S.
lord.
Mishra, learned counsel appearing for the petitioner, made with the consent of other side. Admission hearing of this matter stands adjourned for a week, list accordingly.
There is an interim order, my lord.
Interim order passed earlier to continue.
Oblige.
Silent order.
Lordship, item number 38 to 46, Lordship, I am appearing for the respondents, Lordship.
Yes.
Lordship, I am praying for some accommodation, Lordship, as I have not received any instruction till now, Lordship. Lordship, I am praying for listing in the, I have informed the petitioner.
I'm for the petitioner, lordship.
What are these matters?
This is a matter relating to regularization of the services of the petitioner. They are working on the GMC, Lord.
38 to
46, Lord.
Lordship, kindly give a short date.
huh?
Kindly give a short date. We have.
How much time you want?
Lordship, I am praying in the first week of March, Lordship, so that I can file the affidavit also in the meantime.
4 weeks will grant you. Acha, you
Lordship,
take.
there is an interim order. It may be continued.
Oh, interim order is there. All right. Mr. P. Nayak, learned standing counsel,
GMC, Lord.
GMC, appearing for the official respondent, submits that he is yet to receive instruction in these matters for filing affidavit, and therefore 4 weeks time be granted to file affidavit covering all these cases. Full stop. Ms. R. Das,
R. Kakoti.
R. Kakoti, learned counsel for the petitioners, is present but does not have any objection if the prayer is allowed. Full stop. The learned counsel for the petitioner, however, prays for fixing a date in the matter. Full stop. Considering the submissions made by learned counsel for both the sides, the registry is directed to list these matters again on a non-miscellaneous day in the first week of, or should it be third week of March? Third week of March, second week of March 2023. The respondents to file affidavit within 4 weeks from today.
Second week of month, days.
Let it be third week, because
Third week.
in the week commencing from 13th of March 2023, the respondents to file affidavit within 4 weeks by serving advance copy upon the petitioner's contact. There are interim orders.
Interim order.
Interim orders passed operating in all these cases stand extended until further orders. Yes.
May I please your lordship? Lordship, I beg to mention two matters, lordship. These were last listed on 6th of January. On that day, these matters was left out, lordship. Maybe taken up on Monday, lordship.
What matter?
Compassionate appointment, lordship. This matters leads to compassionate appointment in the forest department. Obvious, lordship.
Lordship, I beg to mention motion item number 13, Lordship. Matter relates to selection and appointment of Kagura's Lordship. We have instructions to withdraw the case from the petitioner.
All right, you are Mr. Your name?
Emma Chaudhary.
Mr. M.R. Chaudhary, learned counsel appearing for the petitioner submits that he has received instructions from his client to withdraw this writ petition, and as such, an order be passed on that behalf. Full stop. The prayer is not opposed by learned departmental counsel appearing for the respondent. In view of the above, this writ petition stands disposed of on withdrawal.
Lordship, liberty may be granted.
No,
Lordship.
liberty, then you have to tell us why you want to withdraw.
Lordship, we received the instructions. He will.
Why? It cannot be that I'll file today, tomorrow I'll withdraw, again I'll file. That is not going to be.
There may be some subsequent development on.
Maybe then you have to tell us what is the development. This is a court of law.
Lordship,
This is not a restaurant or a
Not
shopping
sure.
mall, is it not?
Lordship.
So court follows certain principles. These principles emanate for the CPC, from the CPC.
Lordship. Lordship. May I please, Lordship? I'd like to mention, my lord, item number 23. 23 is a lead case among other two items, my lord. So where the PhD department has filed the affidavit in opposition, and we need to file the reply, my lord. I've taken consent of the other side, my lord.
23 to which case? 23 to
23, 24, 25, my lord.
23 to 25.
Yes.
Who is appearing for the department?
PhD department, he has given me consent, he has just. PhD, yes.
With the consent of learned standing counsel, PhD department appearing for the official respondents. Mr. B. Pukas, the learned counsel for the petitioner, prays for and is granted 3 weeks time to obtain instruction and file rejoinder against the counter affidavit filed by the respondents.
Yes.
Let the matter be listed accordingly.
Obliged.
23 to 20.
May I please, your lordship? Lordship, I beg to mention item number 19 and 20, lordship. Kindly adjourn for a week, lordship. My senior is admitted in hospital, lordship, for his eye.
1 week.
Yes, lordship,
Acha,
for his eye operation.
acha. A prayer for adjournment has been made in this matter on the ground that the learned and arguing counsel is facing a medical emergency and therefore unable to come to court today. Considering the ground on which the prayer is made, same stands allowed. Let this matter be listed again for motion after a week. Same order in 19 and 20.
My lords, I beg to mention item number 14. The arguing counsel, my lords, unfortunately, because of some kidney-related ailment, he's in Calcutta. I beg that this may be listed on next Monday, my lords. It may be
Item
adjourned.
number?
14 minutes.
1-4.
Yes, my lords. Mr. A. Ali,
Uh-huh.
he's in Calcutta, my lords, relating to some kidney-related ailment. He's gone there for treatment.
All right. What do you want?
My lords, I seek adjournment till next Monday, my lords.
On the request made on behalf of the petitioner on the ground of non-availability of the arguing counsel due to medical reasons. This matter stands adjourned for a week. List again on, what is the date? Monday, 1st February?
Yes, my lord. No,
30th,
not
30th of
first
January,
Yes, 30th.
31, 2023 for motion. Yes.
Maybe.
Maybe, this matter may kindly be allowed for listing for admission.
Can you speak a little louder?
This matter may kindly be allowed for listing for admission matter. This is pensionary matter. The retired employee is suffering, his pension has not been finalized. Very urgent.
When do you want it?
My lord, day after tomorrow, my lord.
Day after tomorrow, not today.
Not today, my lord.
Next week. Yes.
Obliged.
Next week.
May I please, your lordship?
Why you want to withdraw?
Lordship, they have withdrawn the order, lordship.
They have withdrawn the order.
Lordship.
Mr. K. Majumdar, learned counsel for the petitioner submits that the impugn order has been withdrawn and therefore nothing survives for adjudication in this writ petition. Full stop. Who is the other side?
Lordship, I am for one, my lord.
Miss
MD Bora.
MD Boral, learned standing counsel. This is your
Lordship, government, my lord. State one.
learned government advocate Assam is present on behalf of the state. Full stop. On the request of Mr. Majumdar, this writ petition stands disposed of as infractious.
Obliged.
For motion, item 2.
Yes, what is this?
This is the matter of compassion appointment, my lord. On last 2 occasions, petitioner take adjournment, my lord. This may dismiss this case. Because
No, what is the compassionate
lord.
appointment? These orders are being passed nowadays.
Lordship, what happened, now this compassion appointment is no more mandatory. From 1st April 2017, it's become the compassion family pension. These are the earlier cases, my lord. But this is no merit in this case, Lordship. The petitioner has applied after so many years. At the time of death of his father, he was a minor. So there shouldn't be any reservation for the post.
Acha, we'll call it up after some time.
My lord.
After,
Oblige, my lord.
after.
Item 3.
Regarding appointment compassionate done, my lord, the
Compassionate.
SLT rejected, my lord. Finally, payroll, my lord.
Compassionate is no longer there.
My lord.
What to do? The scheme has been discontinued.
No, my lord, as per my lord, 15/6/2015, my lord. It is the application prior to that, my lord, 1/5/2000, most probably 17, my lord.
All right, then we'll issue notice at this stage. What to do.
Lordship, Lordship, may kindly have a look, page 38 for a moment, the rejection of the SLC.
Page?
38. Serial number 7, below, Lordship. The name of the petitioner was Kalita. The rejection is under the application was placed 11 years after the demise of government employee. So the proposal does not fulfill the requisite criteria as per point 3 of the OM number 16/2015. The Lordship may kindly have a look the recent apex court judgment, my lord. Very recent judgment, point 9.
He wants dismissal in admission, not in motion.
My lord. Lordship may.
Can we not do that much for him?
My lord, my lord. We'll file affidavit. my lord.
Dismissal in motion is problematic for him.
My lord.
Dismissal in admission, he is sick.
Lordship.
Okay?
My lord.
But my lord, in point number 3, my lord, it is, my lord, prescribe the submission of application within 1 year, my lord.
Mr. Padgiri, the era of compassionate appointment is over.
My lord.
Correct?
My
If
lord.
it is over, it's over. You will make some legal argument, she will make some legal argument, and the court will pass some legal order. That can always happen. But the fact of the matter is, compassionate appointment era is over. Now it is compassionate pension, whoever is entitled to 11 years, 5 years, question, no mandamus. You be very clear on that. Because the whole idea of compassionate appointment is to give immediate relief to the family, not a right of future appointment. That is not the idea. So therefore, those orders don't expect, but to make you feel happy, we'll dismiss it in the admission stage. All right, hard Mr. K.P. Padgiri, Learned Counsel for the petitioner, agree by rejection of the prayer made by the petitioner for appointment on compassionate ground. This writ petition has been filed. First up, it appears that the prayer of the petitioner was rejected by the SLC on the ground that the application was submitted after 11 years
Placed, my lord.
placed with 11 years delay. First up, it also appears that the husband of the petitioner,
No, my lord.
who had died,
Father.
father of the petitioner had died in the year 2010.
10.
Full stop. Ms. Bora, Ms. MD Bora, learned government advocate, submits that the scheme of compassionate appointment has since been withdrawn by the government, and therefore this writ petition is not maintainable. Be it as it may, after considering the submissions made at the bar, this court is inclined to issue notice in the matter. Full stop. NOM 6 weeks. Since Ms. Bora has appeared and accepted notice on behalf of respondent numbers
1, 3, and 5, my lord.
1, 3, and 5. And who's for 2?
2, 4.
Ms. N. Bora, learned SC Panchayat and Rural Development Department. For respondent numbers 2, 4, and 6, service of notice is deemed to be complete in this case. Extra copies of the writ petition be furnished to the learned departmental counsel. Question of maintainability of the writ petition is kept open and shall be considered at this time of admission hearing.
Item 4.
Maybe Lordship.
We should be considered for promotion in grade 3 post, Lordship. We'll issue notice, let them find their response. You are appearing for whom?
Beach Chaudhary, Lordship.
D. Chaudhary is a party.
From tax department, Lordship. Sorry.
Which respondent you are appearing?
All the respondents, Lordship.
All right, heard Mr. G. Kakoti, learned counsel for the petitioner. The petitioners have approached this court claiming that their right to be considered for promotion to a grade 2 post has not been considered by the authorities in a proper manner. Full stop. Mr.
Lordship, I'm here on behalf of Beach Chaudhary.
Whose name should be recorded?
Beach Chaudhary, Lordship.
Mr. B. Chaudhary, learned standing counsel,
Tax department.
taxation department, Assam, appears and accepts notice on behalf of all the prays for some time to obtain instruction in the matter. NOM 6 weeks. Since Mr. Chaudhary has appeared and accepted notice for all the respondents, no formal notice is required to send in this case. Extra copies of the writ petition be furnished to the learned department counsel, so as to enable him to obtain instruction, facilitating disposal of the writ petition at the admission stage.
Obliged, Lordship.
These are computational preferred level, department has recommended peon post, but DLC recommended as a boatman. SLC says that boatman is redundant post.
We'll issue notice
My
here
lord.
4 weeks out, Mr. MJ Burwal and counsel for the applicant. The petitioner agreed by non-consideration of his claim for appointment on compassionate ground. Peruse the amendments made in the writ petition. Stop. Ms. MD Bora, learned government advocate Assam prays for some time to obtain instruction in the matter. NOM 6 weeks since Ms. Bora has appeared and accepted notice for
2 and 3, my lord.
respondent numbers 2 and 3, and who's for 1?
My senior
and-
P Nayak for
And Mr.
PWD.
P. Nayak,
For 1.
Standing Council PWD
4 and
for
5.
respondent numbers 1, 4 and 5. Service of notice will be complete in this case. Extra copies of the writ petition, comma, requisite in numbers, comma, be furnished to the learned departmental council, so as to enable them to obtain instruction, facilitating disposal of the writ petition at the stage of admission hearing.
Deeply obliged.
What is the answer?
If one candidate is rejected in detailed medical examination, he has to appear before the review medical board along with a certificate from this general practitioner, Dr. Lordship. And so far authorities are concerned, Lordship, review medical board decision is final. Yes, it's different that if any direction from honorable court is there, that is different, Lordship. But from the authorities side, review medical board decision is final, Lordship.
So there is a review medical board decision in
Yes,
this case.
review, his detailed medical examination, he was rejected on 3 counts. And in review medical board, he is was rejected on 1 count.
When was this happened? When was this held?
Lordship,
39 to
in fact, Lordship, if one candidate is rejected on review medical board, Lordship, he may appear as a press candidate. That option is there, but his candidature will not be considered again for that subsequent rally, because it may many other persons.
What is that you are holding? What is
This
it?
some instruction was sought for by the Supreme Court.
So we have to examine this matter then.
My lord, let them find the form of affidavit.
Notice not issued.
That's why we'll issue notice. Heard Mr. M. Chanda.
Yes, ma'am.
That's not learned counsel appearing for the petitioner. Also heard Ms. B. Sharma, learned CGC appearing for the official respondent, who has obtained instructions in terms of the order dated 9/1/2023 and placed before this court. As per the written instruction dated 10/1/2023, it appears that if a candidate is aggrieved by the opinion of the detailed medical examination, bracket DME, his only option is to prefer an appeal or review before the review medical examination, bracket RME, whose decision is final. In this case, even the RME has found that the petitioner was medically unfit for recruitment into the service, full stop. From a perusal of the written instruction, it appears that there are some, then you write, Mr. Nath, however, submits that the consideration of the RME is arbitrary and therefore is subject to scrutiny by this court, full stop. Examination of the aforesaid aspect of the matter would require proper pleadings to be brought on record, full stop. As such, issue notice of motion returnable in 8 weeks. Since Ms. Sharma has appeared in exception notice on behalf of all the respondents, no formal notice is required to be sent in this case. You want extra copy?
Yes, Lord.
Extra
I've
copy.
submitted only.
2 copies is submitted. I want 2 more.
You want 2 more. 2 extra copies of the petition be furnished to Ms. Sharma within a week so as to enable her to obtain instruction and file affidavit. Let this matter be listed for admission after 8 weeks.
All right, deeply.
Item 8.
Here, please, your lord. Petitioner might not challenge the order of DLC. In the last.
So your father has got invalid pension.
Invalid
You want
pension,
double.
my lord, under rule 82, 83.
So then where is the question of compassionate appointment?
On medical ground, my lord. Yes, my
So
lord.
you
there
are
is a
getting
provision.
something.
There is a provision, my lord.
There is provision of what?
Office memo, my lord.
No, provision of what? Your father, petitioner's father is getting invalid pension, right?
On medical ground,
On medical ground.
my lord.
So now you also want compassionate appointment.
My lord.
Now that scheme has been discontinued and it happened in
My
2000.
lord, what happened? Petitioner earlier approached before this honorable court on 2009. Order was passed by this honorable court. My lord, kindly see the order of page number 48, my lord. Relevant portion, my lord. 48, my lord.
Mr. Atia, you
Right,
argue
okay.
will hear, but compassionate appointments are over.
My lord,
Those days are gone.
My lord, is a 2017 order, my lord. Can we see page 48, paragraph 8, my lord. Paragraph 8. In such view of the matter, the court is of the view that the case of the petitioner be also again placed before the DLC for reconsideration in the same manner as it was done to the other 2 persons, namely Sri so and so. Accordingly, it is directed that the case of the petitioner be placed before the next available DLC meeting for its consideration as indicated above. Then, my lord, it was.
Which rule you are referring to? Which is the rule you were referring to just now?
42, 43 pension rule.
What does it say?
42 says an invalid pension is awarded on his retirement from the public service to an officer who by bodily or mentally infirmity is permanently incapacitated.
Are you challenging the invalid pension given to your father?
No, ma'am.
Then why are you going into that? The issue is you want compassionate appointment.
Yes, ma'am.
How can it be given? Your father is retired and he is getting pension.
My lord, he is retired on invalid pension, my lord, invalid before the superannuation, date of superannuation, my lord.
Compassionate appointment is given when all of a sudden due to untoward
My lord,
unforeseen.
as per.
All right, this is also dismissal in admission matter. We'll issue notice. Heard Mr. Ajay Atil and counsel for the petitioner. Peruse the amendments made in the writ petition, issue notice returnable in 8 weeks. Mr. R.M. Das, learned,
1, 2, 3, okay.
Standing counsel.
Lot.
Your Water Resources Department appears and accepts notice for appeal numbers 1, 2, and 3, and Miss
S. Borua.
S. Borua. learned
Respondent number 4.
Government Advocate Assam accepts notice for respondent number 4. As such, service of notice is deemed to be complete in this case. Extra copies of the writ petition, requisite in numbers, be furnished to the learned department council. No. Service of notice is complete on 1 to 4. Who is respondent number 5?
5, the chairman of the DLC, my lord, at that time.
1 to 4, huh? Respondent number 5, who was the then chairman of the DLC, has been imputed as a respondent in his private capacity. However, we are of the view that presence of the respondent number 5 is not necessary for the purpose of adjudication of the issues raised in this petition. As such, the name of respondent number 5 be struck off from the record. In view of the above, this writ petition is deemed to be ready as regards a service of notice and be distributed for admission hearing. After how many weeks? 8 weeks. Mr. Atia, why do you suddenly file these cases? These are is there any author decided case where it has been held that
Yes,
invalid
yes,
pension? Which is that matter? Which is that case?
I will place at the time of admission.
May I please, your lordship, the matter regarding area salary, lordship. Petitioner is the supervisor.
We'll issue notice at this stage, that's all.
Lordship, already it is sanctioned, lordship. Page 9.
What to do? Today only you want the money. What do you want today? The money? Some money, little bit. Speak like a lawyer. You are behaving like the client. On the first day, on the motion stage, you want a writ petition to be allowed with money claim.
Page 19, lordship, already it is sanctioned.
Heard Mr. Alamgir, learned counsel for the petitioner, peruse the amendments made in the writ petition. The petitioner claims that her arrears salary amounting to rupees 5,97,846 has not been released by the authorities, despite the amount having been sanctioned. First of, by expressing urgency in the matter, Mr. Alamgir prays for an interim order directing the respondents to release a part of the amount. First of, Mr. T.C. Chutia, learned government advocate, Assam, appearing for the respondent numbers
1, 2, 3, and 6.
1, 2, 3, and 6.
5, 6.
1, 2, 3, 5, and 6. He prays for a short date to obtain instruction in the matter. Mr. B. Chakravarti, learned CGC, has appeared for respondent number 4. First of, in view of the above, issue notice of motion returnable on 10th of February 2023. Since the respondents are already represented, no formal notice is required to be sent in this case. Extra copy of the writ petition be furnished to the learned department council. The prayer for interim relief made by the petitioner's council shall be considered on the next date fixed. Parties to come prepared accordingly.
This is regarding compassionate appointment, lordship, my father of the
This matter pertains to claim for compassionate appointment. Heard Mr. R. Dhar, learned counsel for the petitioner. Where is the amendments made in the writ petition? Ms. M.D. Bora, learned government advocate.
Lordship, here I am appearing the standing council transport
Learned
department.
standing council transport department prays for some time to obtain instruction. Prayer allowed. Issue notice returnable in 8 weeks. Since Ms. S. Barua, learned government advocate Assam, has appeared and accepted notice on behalf of respondent numbers 1, 2, and 3, and Ms. Bora for respondent number 4. Service of notice is deemed to be complete in this case. Extra copies of the writ petition be furnished to the learned department council, requisite in numbers, in order to enable them to obtain instruction, facilitating disposal of the writ petition at this stage of admission hearing. Please.
Deeply obliged.
Item 11.
May please, your lordship. Compassionate appointment, lordship. Her case was recommended by DLC and SLC, rejected, lordship.
Will issue notice at this stage?
Lordship.
All right. Heard Mrs. R. Chaudhary, learned counsel for the petitioner. The claim of the petitioner in this writ petition is pertaining to appointment on compassionate ground. The petitioner is aggrieved by rejection of her claim by the SLC by ignoring the recommendation made by the DLC. Full stop. Ms. S. Borua, learned government advocate Assam, appearing for the state prays for some time to obtain instruction. Prayer allowed. NOM 8 weeks. Since Ms. Borua has appeared and accepted notice for respond numbers. Respond numbers
2 and 4, Lordship.
2 and 4 and Ms. N. Bora. Learned Standing Council, Panchayat and Rural Development Department, Assam, for respond numbers 1, 3, 5 and 6. Service of notice is being to complete, etc., etc., etc. Copies. Facilitating disposal. Yes.
Item 12.
May I proceed? Well, the petitioner applied for the Anganwadi worker, but the authority rejected his candidature, her candidature due to her qualification, which is acquired from Nagaland State Board. Therefore, they reject that candidature. But in the advertisement, nowhere mentioned the out of state cannot apply.
Yes, what is this? What is problem in Nagaland?
My lord, you lord, kindly turn to the page number 26, my lord.
Yes.
In column number 3, my lord. The candidate for the post of Anganwadi worker, Anganwadi worker, and Anganwadi helper should have the qualification of higher secondary pass. In case of this, as higher secondary pass, female candidate must not available in the particular area. Then the education qualification of higher school living certificate oblique Assam High Madrasa pass along with the certificate of BBL. Though it is not clear, but Assam High Madrasa is reflected in this. So, yeah. So, my lord, I have to take instruction, my lord, why the Nagaland board is not.
She is from Nagaland Madrasa or Nagaland normal schools?
My lord is got high secondary pass.
In this one, I have to take instruction, my lord.
Then we have it next week. We obtain instruction. But Mr. Ename, learned counsel for the petitioner. Here is the amendment made in the petition. It appears that the candidature of the petitioner for appointment in the post of Anganwadi worker was not considered merely on account of the fact that she had done her HSLC level.
She done HS.
HS, higher secondary. She had completed her higher secondary course from a recognized school in the state of Nagaland.
Yes.
Mr. Parajuli, Mr. J.K. Parajuli, learned government advocate, Assam, appearing for the official respondents, prays for time till 30 or make it 31st.
31st.
Or should it be 1st February, because we have the Republic Day, 1st February 2023, to obtain instruction and respond to the allegation made in the writ petition. Prayer allowed. Let this writ petition be listed again on 1/2/2023 for motion. 2 extra copies of the writ petition be furnished to Mr. Parajuli. Mr. Parajali, please advise your clients that unless they have a very concrete reason, they should not generate this kind of litigation for needless reasons. There will be a cost accompanied if you find that it was done needlessly. You consider if they don't get it, they don't get it, they get it, they get it. But the person is from Assam, then what is the problem? Advise them. Sometimes they need your advice also.
In advertisement, it is not clear.
That's right. So then what is the point? We'll stay everything. That's all. Yes.
My lord, matter relates to my lord, selection of Gaon Pradhan. So ignoring some fact, my lord, can you see page 29? Page 29, my lord.
Page 29.
Yes, relevant. Number 1, my lord. The candidate should be Indian citizen. Candidate should be Indian citizen. My palace 29.
Yes.
My lord, but the respondent number 6 has been appointed, my lord, ignoring this fact, my lord. Page 44, my lord. My lord, his name is not enlisted in the NRC, my lord. Page 44, kindly see.
No, people whose name are not enlisted in NRC are not foreigners.
Yes, my lord, but some doubt is there, my lord. Since, my lord,
Who doubts? You are doubting.
my lord,
Who has the doubt? Tell us.
since, my
There may
lord,
be doubt, but who has your doubt will not do.
no, no. Yes,
You are an interested person. Who has a doubt regarding his citizenship? You tell us that. It may be correct, but who has the doubt?
it's not clear. Till now, my lord.
Not clear.
Yes.
So what to do if things are not clear?
Since, my lord, my lord, the terms and conditions one, my lord, it's not.
That's correct. You
Yes,
said
sir.
so.
Yes, my lord.
According to you, he is not an Indian citizen or there is some doubt.
Doubt, yes.
But who has the doubt? That's what we are asking you.
Since, my lord, NRC, my lord, the name is not.
You don't have the answer. What
Lordship,
if, yes.
Lordship, executive instruction 162C, Lordship.
Hmm.
It appears that have some alternative remedy if any grievances for selection, Lordship. They may go for alternative remedy, Lordship, file an appeal, Lordship.
That is there, my lord, but my lord, he'll then some protection.
No question of protection. You prefer an appeal. This is which district? Barpeta.
Lordship.
You take down.
But some protection will be.
No, but I'll dismiss your petition then. Either you withdraw or I'll dismiss it. Because we are following a legal procedure.
Yes.
No? It can't be like, give me something since I have come. That is not how courts function. You make out a case or I'll dismiss it if I have to pass an order. Or you can withdraw it with liberty to file appeal.
Yes,
What do you want to?
withdraw, my lord?
You want to withdraw? In this writ petition, the appointment of the respondent number 6 in the post of Gav Pradhan has been put under challenge entirely on the ground that the private respondent does not meet the requirement of which is that? Page
Page
number
29.
requirement of
Should be in the.
qualification number 1 laid down in the advertisement notice. Mr.
J.K. Goswami, Lordship.
J.K. Goswami,
Additional senior government advocate
additional senior government advocate
for respondent 2, 3, 4, and 5, Lordship.
appearing for the respondents 2, 3, 4, and 5 submit that the notification dated 10/4/2018 issued by the government of Assam in the revenue department provides for the scope of filing an appeal in these matters and therefore the writ petition is not maintainable. You are for?
For respondent number 1, Lordship.
Mr.
As doctor.
As Dr. Lalit Council is present on behalf of the respondent number 1. Full stop. At this stage, Mr. Chauhan prays for leave of this court to withdraw this writ petition with liberty to file appeal before the appropriate authority. Prayer allowed. It is made clear that if an appeal is preferred by the petitioner in accordance with law,
Yes,
the same may be considered on merit and disposed of
the time, my lord.
with a reasoned order. Yes, at least writ petition stands closed.
Item 16.
Yes, what is the age exactly?
As on the date when the father had expired, 13 years, 11 months, 16 days, and presently 22 years old.
So these matters, there are a number of
There are judgments. The only gray area is that from the date of filing of the applications, 2 years. Now, for my mother or for me, whatsoever, that consideration is from the date of filing of the application. That consideration was not done. What happens is, my lord, when the district level committee takes it into consideration, the names are either forwarded, that is recommended, or rejected. The rejection or recommendation having not been there, the consideration is not there. So regardless of the time gap, I'm still there in the frame. Me being minor, then
Will
also
issue
not
notice
come.
you obtain
Absolutely.
instruction or Mr. S. Bunny Lalit Council for the petition. Agrees by non-consideration of his prayer for appointment on compulsion ground, the petitioner has approved this court by filing the instant writ petition. Mr. Banik submits that there was enormous delay in consideration of the recommendation of the DLC by the SLC and the,
My case was never considered
by
the district level committee.
Acha. Mr. Banik submits that although the application was filed within
The prescribed time limit as
within
a law.
the time limit prescribed by the standing notifications, the same was not considered by the DLC, as a result of which delay has occurred in this case.
Whether it is placed before the DLC or not, this is not, it is not reflected in the petition.
Cannot be. I cannot go to that extent.
DLC,
Therefore, the petitioner's claim cannot be extinguished only on the ground of delay. Full stop. Mr. J.K. Parajili, Learned Government Advocate Assam, submits that there is a need to ascertain as to whether the petitioner's application was at all placed before the DLC
by
and
the
therefore
department.
by the department, and therefore 6 weeks time be granted to obtain instruction. Full stop. In view of the above, NOM 6 weeks, you are for all.
No, I am appearing only for this one number 2.
Since Mr. Who is for 1, 1, 3 and 4?
1, 3 and 4. Always covered.
Mr. J.K. Parajali, Learned Government Advocate Assam has appeared and accepted notice for respondent number 2. No formal notice is required to be sent to the said respondent. Extra copy of the lead petition was furnished to Mr. Parajali. Petitioner takes steps for service of notice upon respondent numbers 1, 3 and 4 by registered post to Delhi within a week from today. Yes, sir.
Item 17.
Made the loss. Allowed the petitioner here in an MTech in mechanical in electrical engineering from Jharkhand Central University, which your lordship get the certificate after passing out higher secondary in science. My lord, he went there and obtained MTech. The certificate is annexed B page 16, my lord, and the subjects were the composite subjects were annexed page 17. My lord. Electrical engineering, mechanical engineering, renewable energy visualization, and projects. So, my lord, in both electrical engineering and mechanical engineer, he obtained. He also obtained the qualification. Now, then, my lord, there was an advertisement, my lord, filed annexed D on 25/5/2022, where he applied. Admit card was issued. He appeared in the written test. Then, my lord, the Tabak Viva came. Viva is scheduled on 1st, 2nd, and 3rd of next month. But, my lord, the rejection list was. I have an admit card also of the examination. Rejection list was out, my lord. Last time I see at page 29. Where I was found step to be having no requisite qualification.
Where is it?
Now page 29, and the as per the advertisement, the requisite qualification prescribed was diploma in mechanical or automobile engineering. I got a mechanic also, and that is master degree. Page 29, what is serial number 57 is my name. He is integrated MTech Malus. Kaushik Kalita. It is no requisite qualification, but he was allowed to sit with the examination, and it is the term for Viva. So, first is BA. Now, I am told there are some other restrictions also pending, where the BE passed were disqualified, and this court has allowed interim order to allow them to appear. Even their application is not accepted at all. So this court has directed them to, if the online is closed, the offline to accept it.
Where is the order? Let us see.
Order.
My lord, actually, I have received the instruction, my lord. Please, your lordship can listen. Yes, sir. আপনি হিয়ারে ফেলেই বলছি কি লাভ হবে he has no case at all now.
But he has not shown failed, my lord.
No, that is different. He was provisionally allowed to see.
But in the list, it is written.
No,
no
that is
requisite-
this is qualification.
So we allowed to sit in the examination provisionally all. But after that we scrutiny. But even then, my lord, even he is allowed to sit, my lord, that is decided. He is, my lord, in screening case, he is not qualified. So his matter has gone. He will not get anything.
Then you have to file an affidavit.
Yes, my lord, they can file. Because his EWS quota, my lord.
They say they've given, you can have a look at this, yes.
He was provisionally, all are allowed to provisionally, my lord. But we have there is a procedure, my lord, we can scrutiny later on. But his qualification is not as per the advertisement. That's why it's in rejection list, my lord. But even in result also declared, my lord. In screening test result, he was provisionally allowed. He is provisionally allowed to sit in the.
Can you file an affidavit by Friday? We'll have it on
Yes,
Monday.
definitely, madam.
All right, I heard Mr. R.P. Sharma, counsel, senior counsel, assisted by Mr.
Devasis Dole.
Devasis Dole.
Counsel appearing for the writ petitioner. The petitioner had submitted his candidature for appointment in the post of motor vehicle inspector, MVI, under the government of Assam Transport Department. But after the written test, his name was included in the list of rejected candidates on the ground that
there was pyro, madam.
Petitioner did not have the requisite qualification. Today, when the matter is called up for motion hearing, Mr. T.J. Mahanta, learned senior counsel, assisted by Mr. P.V. Datta, learned counsel for the APSC, has produced a copy of the written instruction, according to which the petitioner had failed to qualify, failed to secure the cutoff mark
In his respective quota, his EWS quota.
In the EWS bracket male quota in the screening tests, and that is why he has not been called for the interview. First of all, according to Mr. Mahanta, although the petitioner did not have the requisite qualification, yet similarly situated candidates, including the petitioner, was allowed to provisionally participate in the written test. But in this case, his name was not selected as he had failed to secure the requisite cutoff mark. The learned counsel for the APS raised for time till 27/1/2023 to place those facts on record in the form of an affidavit. Prayer allowed. Let this matter be listed again on 31/1/2023. In the affidavit on behalf of the respondent number
1, 2, and 3.
1 and 2 shall be positively brought on record on or before 27/1/2023 by serving advance copy upon the petitioner's counsel. Let this matter be listed again for motion. Miss M.D. Boral, I'm standing counsel, Transport Department, is present on behalf of respondent numbers 4 and 5.
Would it be necessary to call for the records also, my lord?
Sorry?
Would it be necessary to call for the records if your lordship should?
No, if they file an affidavit saying that he does not meet the cutoff mark, I think that will be end of the matter for your client.
How the cutoff mark?
Unless you allege malafide.
Yes.
In which event this
Then I'll appeal. Then I will appeal.
Well, what will you look into? If he has not secured the cutoff mark, the matter is over for
Now,
you.
how the cutoff mark was, because they have not furnished anything to me. They have not implemented till date. Because the rejection list was on another ground, not on that ground.
No, rejection list is as per prior to declaration of the result, my lord. In there, provisionally allowed, when he was provisionally allowed, it was clearly
No,
mentioned.
my lord, there will be true, my lord, but I'm the first time hearing this thing, my lord. My lord, that after the written test, without the result being out, the viva was rejected. That is, I think, something surprising. Anyway,
Item 18.
This is not written, this is screening test. This is not written test. This is not carried the mark. This screening test.
May I clear it? The petitioners are the candidate of the board hunt. And as per advertisement, they were appeared before the.
Like in the earlier matter, Lordship.
There is an appellate provision.
Lordship, already representation has been given to the deputy commissioner of Golaghat district, but
You are challenging the appointment of?
I'm challenging the selection days.
First of all, so many petitioners cannot come together in this matter. All of them can't be appointed.
Lordship.
Then the writ petition has to be dismissed on this count. If 10 petitioners come, you cannot say that out of 10, give it to 3 of us. That kind of petition is not maintainable. So you prefer an appeal?
Yes, Lordship.
In the meantime.
As per Executive Instruction 162C, Lordship, before the Commissioner, Upper Assam Division, Lordship, it is Golaghat, Lordship. Divisional Commissioner, Lordship.
You prefer an appeal, we'll ask him to look into the matter and pass appropriate orders. Beyond that, not possible. Because these fishing enquiries through writ petition, we have had enough. You are not selected, file a writ petition, something will happen, court will issue notice, call for record. If you get something good, otherwise no problem. Those things cannot continue anymore. Your name, please?
P. Boiragi.
Heard Mr. P. Boiragi, Learned Counsel for the petitioner. In this writ petition, 12 petitioners have joined together to challenge the process initiated for the purpose of selection of Gaon Pradhan, inter alia contending that there are irregularities in the selection process, in as much as under the influence of the ruling party, merit has been ignored while recruiting the private respondents, while recruiting the candidates. However, none of the appointed persons are party to this proceeding. First up, Mr. J.K. Barua.
J.K. Goswami.
J.K. Goswami,
Additional
Additional Senior Government Advocate Assam.
Respondent 2 and 3, Lordship.
Appearing for respondent numbers 2 and submits that under Rule 162.
162C.
162C of the
notification dated, Lordship, it is 10 April 2018.
The petitioner has the remedy in the form of an appeal to be preferred before the Deputy Commissioner of the district.
Divisional Commissioner.
Divisional Commissioner of the district.
Upper Assam.
And therefore, Divisional Commissioner of Upper Assam. And therefore, this writ petition is not maintainable due to availability of alternative remedy. Mr.
S. Datta.
S. Datta, Learned Counsel for the respondent number 1 is present and makes a similar submission. At this stage, Mr. Boiragi seeks leave of this court to withdraw this writ petition to prefer appeal before the statutory appropriate authority. Prayer allowed. If an appeal is preferred by the petitioner in accordance with law, the same be considered on merit and disposed of by a reasoned order. Writ petition stands closed.
Item 21.
Yeah, please, madam. The petitioner is working as an assistant commander in the.
Who is the CGC here? Who is the Central Government Council?
Item 21, sir.
What is this? Somebody is in medical leave, undergoing treatment, and you conduct an inquiry behind his back.
May I please proceed? I am not allotted this matter. Concerned advocate, so is I have to.
All right, if he's not there, what is the relief you want?
My lord, they should allow me the opportunity of participating in the inquiry proceedings by giving me the opportunity of cross-examination and putting forth my defense.
Yes, Mr.
That
Gogoi.
is the only relief I could.
There is no violation of the lordship's substantive law and procedural provisions.
Will stay it and let it remain in the cold storage unless you concede that you will start afresh by giving him time. Somebody is sick, you grant him medical leave, he is in the hospital and you pass an inquiry report against him. You expect the High Court to accept it. Definitely we will not accept.
Give 1 week's time, I will obtain instruction in this regard.
Instruction on what?
Regarding lordship, whether he is lordship, that written his reply is filed or not, other things also.
No, reply will not do. If he was in hospital, this report will be set aside.
Lordship, give some time, lordship, I will.
All right, Friday we'll post it.
Friday, my lord, I'm up to station, my lord. It will be Monday or.
On Monday, heard Mr. Armandal and counsel for the petitioner, assailing the expert inquiry report dated 6/6/2022. The instant writ petition has been filed inter alia contending that the inquiry was conducted behind the back of the petitioner. That too, at a time when he was hospitalized due to medical reasons. Full stop. Mr. K. Gogoi Lanet CGC prays for time till Monday 31/2023 to seek instruction and make and respond to the allegations made in the writ petition. One extra copy of the writ petition, 2 extra copies of the writ petition be furnished to Mr. Gogoi. Let this matter be posted again on 31/2023 for motion. You see, whether he has got a chance or not is not important. Important is whether he was hospitalized, whether he was on medical leave. If he is on medical leave,
Then this back to the lordship back for.
either you concede or we'll pass our judgment whenever time comes. But then we'll have to stay this.
On Monday, lordship, I will exercise if lordship possible.
You make them understand.
Lordship may dispose of that on Monday, lordship, if I am not able to, do, then lordship may that particular steps from as per.
No, you get a written instruction.
Lordship,
I'll provide and finish it off.
I'll.
If you make us write a big judgment on every matter, then we'll also take our time.
Lordship, I'll.
You will suffer.
I'll do.
You can't do that. You see,
I'll
people
do.
are
I'll do.
understandable. Some employees may be even irritating,
Lordship.
but then authorities cannot
Lordship,
behave like the individuals. They are the ones in power. They have to be fair and transparent always. They can't behave in the manner another. So while we appreciate that your authorities have to deal with different kinds of people who sometimes could be very, very irritating, but you cannot slide down to that level.
We cannot avoid also the apex court judgment also.
You cannot. So
I'll address this.
please make them understand.
I'll.
We also don't want to interfere unnecessarily, but if they compel us, we'll do it.
I'll.
Yes.
Since Lordship is not passing any interim order as of today, because this is for some Monday, I hope you'll instruct the client.
Lordship already
not
since September
Only that.
2009.
I'm not asking for observation
On
from Lordship.
Monday, we'll see whatever happens.
Lordship. Allah.
This is also Gauguda.
Yes, Lordship, same matter.
But the council is not present.
Lordship.
And appears for the petitioner on call. This matter stands adjourned for a week. Yes, Passover one matter actually. It's item 2.
This matter.
What is this case about?
Regarding compassion appointment, my lord. The father of the petitioner died in the year 2012, my lord. After that, the petitioner has applied in the year 2017 when he became major, my lord. So it's not a case, fit case.
Take down petitioner's petitioner's counsel is absent today, even on the second call. It appears that even on the second call, Miss MD Bora, Lana Standing Council.
Same government advocate.
You hold 2 placards. When you are standing council transport, one you are government, otherwise it confuses us. Okay. You can use 2 different hats. One's red, one green. And a government advocate Assam submits that the father of the petitioner had died in 2012. And therefore this petition seeking an order for consideration of his case on compassionate ground is not maintainable in law. Full stop. Be that as it may, since the petitioner's counsel is absent today, I am not inclined to pass any adverse order in the matter. Register to, however, list this case again on 8/2/2023 as a fixed item for motion. If the petitioner's counsel remains absent on the next date as well, consequential orders will follow.
I'm deeply obliged.
All right, this on item 26.
My lord, here the provisional pension has been paid. With regard to his regular pension, my lord, there was a requirement of a post being created. But I not have the updated information as on today. The lordship can have it after 2 weeks. I'll place those instructions.
You are receiving provisional pension.
Yes.
Your name, please?
R. Hawk.
R.
R. Hawk on behalf of AIUddin.
Mr. R. Hawk, Learned Counsel is present on behalf of the petitioner and submits that his client is receiving the provisional pension. However, the regular pension has not yet been released. Mr. UK Nair, Learned Senior Counsel appearing for the
High Court, my lord.
appearing for the Guwahati High Court. submits that some instructions are still awaited and therefore this matter will be posted again after 3 weeks, by which time he will appraise this court as to steps taken for settling the pension claim of the petitioner. Mr. D. Nath, learned senior government advocate Assam, is present on behalf of the state.
Number 1.
State stroke respond number 1. On the request of Mr. Naya, this matter stands adjourned for 3 weeks.
Item 27.
Here the petitioner is the wife of a deceased CRPF employee. His terminal death and terminal retirement benefits have not been paid to the wife by the CRPF respondent, saying that he had availed a personal loan sometime when he was in Orissa, and the bank has requested that his loan be adjusted against the death benefits, my lord. That, my lord, is what I am against, my lord. She would kindly have the page 14, my lord.
Who is the respondent number 6?
No, the respondent number 6 is a chief manager of the State Bank of India. Copies have been served upon them, and someone has entered appearance also. They don't want to recover the loan by the legal process. They write a letter to my employer of my husband, saying that please give us all the money that you owe to his wife or to his widow.
We'll have it on next Tuesday.
Madam.
Because they are not present today, and if they are not present on the next day, or Mr. R. Majumdar, learned counsel for the writ petitioner, none has appeared for the respondents, although the name of the respective counsel have been duly reflected in the cause list. Since the respondents' counsel are not present today, this court is not in a position to proceed further with the matter. Full stop. However, considering the urgency involved in this case and on the request of Mr. Majumdar, this matter is directed to be posted again on 31st of January 2023 for admission as a fixed item.
Madam. Obliged, madam.
Item 29.
What is this matter?
Lordship, I am an employee of Numaligarh Refinery Limited, and I am kept under suspension since last 17 months. Suspension notice, Lordship. Lordship, I have filed the affidavit in reply for this case, where I have properly proved the illegal activities of few senior most authorities of NRL. The fact is that few senior most authorities of NRL are involved in illegal and unethical activities, and for which I filed few RTA.
Which is the order of suspension? Which page?
Page Annexure 1, page 28.
Are you receiving subsistence allowance?
Lordship, yes.
What is the inquiry has started?
Sir, Lordship, I am not receiving subsistence allowance because I am not going to register my attendance there. I am not receiving subsistence allowance. Enquiry, Lordship, enquiry completed, and I have given my detailed representation of the enquiry report. But since last 3 months, they are delaying, they are intentionally delaying the departmental proceedings. It has crossed Lordship 17 months, but they are, first they conducted the internal inquiry. I submitted my written representation on the internal inquiry, but later they, on my request, they conducted external inquiry. External inquiry is completed. I submitted my detailed representation on the inquiry report, but since last 3 months, they are not giving any reply.
You are appearing.
I'm appealing. 226, madam. Inquiry is completed, madam. We are at the stage of passing the order.
Then why are you keeping him under suspension?
Because, madam, he himself is saying that he will not attend duties till the cases are over, madam. In writing, he is saying, madam.
Where is the
It
writing?
is absurd, madam.
Where is the writing?
Lordship will kindly take my affidavit, madam. His letter dated 3/11 starts at page 177, my lord, continuous page.
Yes.
Last page of that letter, my lord, page 180, my lord, he says that he'll be out of station till disposal of all his cases.
But Lordship, I'm at station now.
No, just a minute. You have said, let him now say. There is a,
My
you may appear in person, but we'll follow the court system, huh? You take your seat.
No, he was not reporting for duties. He was not signing the attendance register.
So the inquiry has gone ex parte or?
No, he has participated.
He has participated.
It was conducted by a retired honorable judge of this honorable High Court, madam.
Achha.
Because he wanted an independent inquiry officer. Honorable Justice P.G. Agarwala was the inquiry officer, madam. He has given his report. That report also he has made it a part of the present petition, madam, by filing it in the affidavit. in
What
reply.
does that report is under which provision?
My lord, there is a provision in the CTA rules, my lord, that we can appoint an independent
All right.
person.
What does the report say?
The report has held him guilty of 2 charges, and charge number 1 and 2 has been held to be proved. 3 has not been held to be proved.
Then what is the action that is proposed against him?
My lord, that I am not in a position to, because that instruction I do not have. Because the disciplinary authority has to take a call, my lord, because he has given his representation. Let us not go into that matter because he has made allegations against the inquiry officer. A lot of things. I don't want to bring all that, my lord. Now we are at this stage. We are at the stage of passing the order, my lord. What order is being proposed, my lord? That instruction I do not.
Mr. Chaudhary, you are appearing in this case.
I'm appearing for respondents number, my lord.
7, 8, and 9. 7,
8, 9, and 10.
He has made them parties by name, my lord. 7 has retired, so has 9, my lord. In the meantime. 8 was the director technical at that point in time. Now he is the managing director, my lord. And 9 is his reporting officer. I mean 10, my lord. 9 was the discipline authority. Yes, yes. He says that he will remain out of station until all his cases are finished.
Achha, first of all, do you want any assistance, legal assistance to be provided by the court in this matter, or you want to handle your case yourself?
We provided by court. I want to have a legal assistance. Lordship, I provided the affidavit in reply, wherein I have provided properly proved the illegal activities of the respondent authorities. The fact is that I submitted few written applications and RT applications in NR for the illegal activities of the respondent authorities 8, 9, 10, and 7. And but as no actions were taken by the NRL management, I was compelled to report it to the competent external authorities. But
so, Mr. Petitioner, you see, the court of law is not concerned with any personal likes, dislikes, ego, etc. We are not concerned. We will go strictly by, this is a service matter, we'll go by the rules. They say they have completed the inquiry proceeding and they are in the process of passing an order. Correct?
Yes, Lord.
If the order goes against you, then this writ petition becomes infructuous immediately. Nothing will be there.
Yes, Lord.
You have to challenge that order. And there are parameters for challenging that order, which will go by the law, not by what you understand. Right?
Yes, Lord.
That is why we are asking you, for now, would you want the court to give you some legal assistance? We can request some senior counsel to appear for one day and see if something can be done in this matter. But if you are making allegations, wild allegations against the senior officials, these are matters which will have an adverse bearing on the, because the organizational discipline has to be maintained. You may or may not agree with many things. That happens in every organization. But as long as you are a part of the organization, you have to follow the discipline. Otherwise, no organization can run. There, the court will not be of much assistance. We will see whether they have violated the procedure, whether they have given you opportunity to present your case, whether their views are based on materials on record. Beyond that, we can't help it. So therefore, if you want, then we can request our senior counsel to assist you. But the parameters are very limited.
Okay, Lord. Lordship, in addition of this repetition, another repetition is pending for my demotion matter, which is in hearing stage. And another criminal petition is also pending between me and NRL management. NRL management has filed criminal petition against me for crossing my FIR. Because I reported about many illegal activities. I have proved it in the affidavit in reply, Lordship. With relevant evidence, I have proved it. These are not allegations, I proved this with relevant evidence.
So what is to be done today?
Lordship, let us wait for the order, madam, what the discipline authority passes, madam.
What order you want today, Mr.? Your name is your.
Dipu Das.
What order you want today?
As they are delaying the departmental proceedings, Lordship may kindly give directions to them to complete the departmental proceedings within a specified time period. Lordship. It will be very helpful.
How much time you want? 4 weeks. All right. See, Dipu Das, the petitioner is in person is present before this court and submits that due to enormous delay in conclusion of the disciplinary proceeding, his interest has suffered serious prejudice. Full stop. The petitioner also submits that he is still under suspension and therefore the disciplinary proceeding is required to be expedited on the basis of an order of this court. Stop. Mr. N. Deka, learned standing counsel.
Not standing counsel, counsel for.
Learned counsel appearing for the Numaligarh Refineries Limited, appearing for the official respondent, submits that the inquiry proceeding has already been concluded and the authorities are contemplating to pass appropriate order on the basis of the finding of the inquiry officer. As such, 4 weeks further time be granted to appraise this court as to what action has been taken in the matter. Full stop. Mr. K.N. Chaudhary, learned senior counsel, assisted by Mr. N. Gautam, appearing for the respondent numbers 7 to 9.
7 to 10.
7 to 10 is present and submits that some of his clients have already retired from service but he is present in this case only to defend the reputation of his clients, against whom some wild and baseless allegations have been made by the petitioner. First, be that as it may, since Mr. Deka submits that the inquiry proceeding has already been concluded and an order of and an appropriate order on that behalf will be soon passed by the disciplinary authority, this writ petition is adjourned till 2nd of March 2023. On or before the next date fixed, the respondent authorities shall pass a final order on the inquiry report after following the due process of law and serve a copy thereof to the petitioner.
Thank you. Public.
If I may be allowed to file affidavit within a week, my lord.
You want to file?
Affidavit, my lord. Within a week, I'll file, my lord. Within a week, madam.
In fact, I hear that some development is also there in this matter.
What
Not on this ground, but on some other ground, the petitioner has been, my lord, already discharged from service. That order also I have not come through, my lord. Let the affidavit come, my lord. Next week we can.
We'll have it after 2 weeks then.
Well,
yes.
Not Mr. B. Patel, learned counsel for the petitioner. Also have Ms. A. Gayan, learned CGC, who pays for 1 week's further time to file affidavit. Prayer allowed. List this case again after 2 weeks. In the meantime, affidavit on behalf of the respondent will be brought on record.
That's the blessing.
Table.
Item 31.
May I please, your lordship? Lord, in this petition, my lord, we are challenging an order of, my lord, promotion of the private respondent, my lord. Lord, in fact, this honorable court was directed the state council to bring the records, my lord, after a length hearing. But, my lord, till date, those records has not been, my lord, placed before this honorable court. PWD, my lord.
PWD is not even present.
My lord, Mr. R. Dhar.
Huh? Where is he? Can he come or we can make some, huh? Yeah, ask him whether he is willing to come. You are challenging whose promotion?
My lord, the promotion of the private respondent, my lord. My lord, may be pleased to find the promotion order, which I have challenged at page 55. My lord. Divisional head assistant, my lord. I am the senior in that division, my lord. In spite of that seniority, my
Page
lord.
55.
Yes, my lord.
What is the criteria of promotion?
My lord, that's the, my lord, they could not place, my lord. We have relied upon a rule, my lord. But they are saying that that rule is not applicable. It has been come into force after this promotion order. That's why, my lord, this honorable court wanted to know that basing on what criteria you have promoted, bring those records, my lord. But till date, my lord, they are silent, my lord. If, my lord, just I am troubling my lordship, my lord, with an order at page 2009-2022, my lord, passed in the same, in this petition, my lord. Kindly, my lord, produce the order, will clear the case, my lord.
Yes. Let him come.
Mal.
Item 32 to 33.
Yeah, please.
Kindly see, my lord, paragraph 2 and 3, my lord, I need to read, my lord, paragraph 2, my lord. So the petitioner state that initially she has been appointed as Anganwadi worker 5, Anganwadi helper, 5 appointment letter
Sir. Dated sir. Issued by the National 14 in the number 350 Dakshin Senior Dakshin Port Soba under Lahorigas ITDS project. Subsequently, in the year 2013, she was transferred to the number 312 Dakshin Senior Dakshin Port Suburi in the same post of Anganwadi helper. And since then, she has been working in the center till the date without any break. So what is the WPC number
My lord.
7315?
First
Answer the questions of the
Yes.
court, Mr. Counsel.
my lord.
Listen to me. First, answer the queries of the court. Have the decency to do that. I am asking you questions. You are going on saying things you want. What is this writ petition 7315 of 2021? Who has filed this?
Lordship, I am appearing for 731.
Yes, what is this
This
matter
matter
about?
relates to appointment of Anganwadi worker, Lordship. I have been selected candidate for the post of Anganwadi worker. Lordship, kindly see my writ petition,
Where is that petition? Give me.
item number 33. Page 20. Page 20 and 11 portion, page 21, maybe seen, Lordship. Page 21, serial number 2. I am Nadira Khatun, Lordship. Page 21, serial number.
So you are challenging the appointment of any candidate?
No, Lordship.
Then?
I am praying for appointment pursuant to the selection list, that selection list. And following this selection list, Lordship, kindly see page 22. Page 22. Serial number 5, Nadira Khatun, Dakshin Chenimari, Dakshin selected candidate. Now, Lordship, in last paragraph, Lordship, it was issued by the director to the child development project officer. You are requested to issue the letter of expression of interest to accept the voluntary service of as Anganwadi worker to the selected candidates against the Anganwadi center immediately.
Page number?
Page 22. Last paragraph.
So which is the Anganwadi center you are interested in?
Dakshin Chenimari, Dakshin Suburi, center number 312.
Now, this person called Nadira Khatun, who is the petitioner here,
Yes, Lordship.
you want that her appointment should be made.
Yes, Lordship, pursuant to the selection list. And he has come, Lordship, she has come, Lordship, to challenging the validity of my selection list because it was already past 1 year.
Who has come?
So, item number 8 petition in 32.
In my petition.
He was one of the aspirant, Lordship.
Actually,
Since my appointment was not made pursuant to the selection list in 1 year.
Already expired, my lordship. It was published on 14 May 2020, my lord. And expired after 1 year. Mr. Chutia, what is the matter? Neither writ petition has any private respondent.
Yes, sir.
He is challenging,
each other.
he is challenging his appointment, his,
Yes.
with his time, but they have not made each other party.
That's why our whole problem is there. In writ petition 138, we have filed an affidavit. Jasmin. Only said by one stand is that, but due to the pendency of the 70 writ petition 7315/2021, upgradation could not be done. That is the Malar stand. And in the meantime, select list has been expired after 1 year. That is the case. So, Malar, whole board the petitioner, Malar, but I may be sent to the director, Malar, he will examine all these things in presence of both of them. They will produce all these things, but I have received a record, but I have not gone through it, Malar. I will have to assist the court, Malar, I will have to go through it. That's why the matter may be disposed of. Both are claiming their selected candidates, Malar. So better
No, we have to decide this. You want time to go through the record, that's okay, but there is no point sending it to the. They have to.
Some time may be given, my lord, I will go through the record, I will assist the court.
Lordship, she is not claiming as a selected candidate.
Yes,
She's not
but
claiming.
then we'll have to pass an order. He wants a little time. In item 32, Lipo, Mr. A.N. Ahmed, learned counsel for the petitioner. Item 33, Mr.
Eti Sarkar.
A.T. Circle, learned counsel for the petitioner. Mr. T.C. Chutia, learned additional senior government advocate Assam appearing for the state respondents. In both these petitions submits that he has recently received the records and therefore seeks 10 days time to go through the same for assisting this court. Considering the nature of controversy involved in this petition, this court is inclined to grant 10 days time to the learned government advocate Assam to examine the records. Register to list both these cases again after 2 weeks as fixed items.
Item 34.
Next, in this case, the petitioner also lordship was his engagement was cancelled by the order at page 28. Thereafter, he approached this honorable court. This honorable court demanded that the matter to directing the commissioner to decide on the basis of the inquiry report. In the inquiry report, nothing was against him. But the commissioner, by the impugned order, he has disagreed with the findings of the inquiry report. But the same was never communicated to the petitioner and the speaking order was passed.
What is under challenge in this proceeding?
The impugned cancellation order as well as the impugned or speaking order, my lord.
Where is it? 1/11/2017.
Cancellation of 1/11/2017 with the cancellation order, my lord. And the impugned order was is 5/1/2022, my lord. At page, Lordship will find at page 41. The impugned speaking order, my lord.
What is GRS?
Gram Rozgar Sahayak. Was arrested in connection with the police case, my lord. 3 persons were arrested from the same block, my lord. The other 2 were allowed to continue. The petitioner had his application has
So
changed.
what is the order you are seeking today?
Lordship will, my lord, allow the petition, my lord,
And
because this is.
allow it without a hearing.
I'll apprise your lordship, my lord. I'll apprise you the facts before lordship, my lord.
You want a final hearing today?
Yes, my lord.
Today will not be possible. You can choose any other
Issue-
date.
Simple issue, my lord, whether the reasons for disagreement was communicated to the petitioner or not.
Today there is a problem. It will not be possible. You can choose any other day. This court may not be able to sit in the second half.
My lord. Then, my lord.
That's it. We have received the instructions. So, need 3 weeks time for filing the affidavit.
3 weeks time.
So it's-
Why? You are not writing a thesis, you are writing an affidavit.
Time may be done,
We'll grant you 2 weeks.
but.
Heard Mr. Ayed Sekal having counsel for the petitioner. Also heard Ms. M. Bora Lana standing counsel PNID Assam. He submits that she has received instructions and therefore we granted 2 weeks time to bring the same on record in the form of an affidavit. Ms. M. D. Bora Lana, Government Advocate Assam, is also present on behalf of the state respondent. On the request of Learned Department of Council, let this matter be listed again on 2nd of February 2023 for admission as a fixed item. Affidavit, if any, be brought on record positively. No, second, no, it should be 7th. 7th. It should be positively brought on record on or before 3/2/2023.
Obligement.
Item 35.
May I please proceed? But in this case, my lord, I have got an instruction, but it is not clear, my lord. I am see some more clarification from the.
There is an interim order operating.
Interim order.
Heard Mr. A. Ahmed, counsel for the petitioner, also heard Mr. J.K. Paradipil, government advocate Assam, appearing for the state, who submits that although some instructions have been received by him, yet the same is not clear enough for him to make a submission before this court. Mr. Parajali therefore seeks posting of this matter again after 3 weeks. Prayer allowed. Let this petition be listed again after 3 weeks. Interim order passed earlier to continue until further orders.
Obliged.
Item 36 and 37.
May I please, your lordship? My lord, the matter relates to, my lord, compassionate family pension scheme, my lord. Lord, what has happened, my lord? The petitioner is a widow, and I was surviving on the salary of my late son, my lord. And my late son had also 2 wives. Now, my lord, the pensionary benefits, my lord, on the death of the, my lord, deceased of my son, my lord, both the wives are enjoying, my lord. And there is a scheme of the government, my lord. If any complaint is made by the eldest of the family, the government will, my lord, proportionate the portion of the, my lord, family pension. If, my lord, for a moment, my lord, the clause 5 is very clear, my lord. At page 21, my lord.
Petitioner is the mother.
Mother, my lord. Mother and very, my lord, old aged person, my lord. At page 21 will clarify, my lord. I am referring to clause 5.10, my lord.
Yes.
Lord, clause 5.10 says, my lord, it is also provided that if the parents or other eligible family members are not looked after by the compassionate family pensioner, on receipt of such complaint from them, the competent authority will issue orders apportioning the compassionate family pension appropriately among the other eligible family members. Now, my lord, here is a case. My lord, herein, this compassionate family pension is now being enjoyed by both the, my lord, wives, which I have made the parties also, my lord, in this petition. Now, I made a complaint before the, my lord, that government at page 23 annex 4, my lord.
Yes.
Now, my lord, basing on this complaint and relying on this clause 5.10, my lord, the government could have, my lord, apportioned this, my lord, portion of a share of my share, my lord, and could have diverted the some amount to me for my survival, my lord. But till date, my lord, they are silent. That's why, my lordship, I am now before my lordship, my lord. My senior friend is appearing for one of the wife, my lord.
Yes, who is for the government? What is your stand?
Let's say if we have not received instruction, let's say, in similar other matter, which matter is there, let's say, in that matter, the wife, petitioner has 2 wives, they have claimed for the pension, and the first wife was getting pension, and
Lord, the division bench order has come, my lord, regarding this Muslim second wife. This honorable court has held that second wife is not entitled.
What do you ask? Because what will happen is that myself, the petitioner in the second case, and another are co-wives, Muhammad and Faith. The husband had married without taking the permission under the conduct rules. He was a serviceman. Accordingly, after his death, when the claim for pension arose, it so arose that since he had married me, the second wife, without the permission, it was held to be a misconduct, the entire thing. I approached this honorable court, and the other wife, the co-wife was also there. Under the law, I do not have a right to get any pension. It's the first wife who gets it. But wisdom was there, and both of us, we agreed to apportion it 50-50. We'll take it that way. Accordingly, while the stigma of misconduct was removed by division bench, it was held that you file appropriate application saying that you want to jointly share, so things would proceed. We did. And it was being given equally. Suddenly, the authorities of the administrative department, they issued an order jumping over this entire scheme and granting all benefit to the first wife. This occasion might need to come before this honorable court by way of a second writ petition. I came saying that when we had agreed otherwise to share it, there was no reason for the authorities to pass another order giving the first wife. And the first wife is also represented. Now, the mother comes in to say that my son had two wives and both of them are playing foul. My lordship, with all respect, so far as the scheme is attention is drawn at, it is provided that if the parents or other eligible family members are not looked after by the compassionate family pensioner, on receipt of such complaint from them, the competent authority will issue orders apportioning the compassionate family pension so and so. First of all, my address is normally shown in the writ petition. My address is there on record. And secondly, his complaints met out, if these things are taken on the face value, my lord, any person can make a complaint. Parents or other eligible family members. So any person can make a complaint. The crux is the government is first to come up with a solution that how to get rid of the order which is there challenged in the second writ petition. Because there was an arrangement done. After that is done, comes the second part. What is to be done in his case for the mother? No, the mother's case. So the mother has to establish a case of neglect, and possibly if senior persons are being neglected, then there are orders to be followed. But the difficulty would come in my case is that even if the arrangement is followed, they cannot create two accounts to disburse the payments in the first wife and second wife's name. So possibly that part has to be addressed. I understand, although we are in agreement, I do not have a right in law. It's only by the scheme of arrangement and the
Who is appearing with the first wife?
first wife is he would not. We are agreeing to that.
My lord, in this case, my lord, full bench judgment came, my lord. In this full bench judgment, my lord, Junupa Bibi judgment was accepted, my lord. As per the Junupa Bibi judgment, only first wife is entitled for pension, as per the, my lord, 143 pension rule, my lord. Second wife is not entitled.
That's all right. Here we are concerned with the mother's.
Mother, again, I have no objection, my lord.
You have no objection.
No.
Why don't you make a three-part division of the amount? Give 1/3 to mother, 1/3 to. And live in
Presently, my
peace.
lord,
And live in peace.
my lord, regarding mother, my lord, but regarding the, my lord, second wife, since the, my lord, full bench judgment came, my lord, as per the, my lord, judgment, my lord,
We were under an arrangement which was done in the honorable court, and that's reflected in the orders itself. I still hold to say that the second wife does not have a right, but only by virtue of the arrangement and no objection raised that this thing follows.
Can you file an affidavit where it can be divided in three parts? We'll close the matter.
my lord, for that part, my lord, I need some time.
That somersault is not permissible perhaps because you'll be bound by law. In the honorable court, it was the case that I had no right to get pension, nothing of that sort. But then the first wife came, it's there on record to say that I have no objection, we can share it. Just like we felt now that we can share with the mother. Fair enough. If need be, the mother is neglected, it can be done three parts. I'll have a word with my parents. Let the matter be taken.
Yes, if you agree, we'll not go into the legality.
Yes, my lord. My lord, for that, I need some time.
How much time?
My lord, 2 weeks. 2 weeks, my lord.
A small
Oh,
instruction.
my lord, any day, your lordship.
File a joint affidavit with
My
all
lord.
of you. We'll
File
close
it.
the matters.
Joint affidavit may not be possible to the others. I'll file for my part. Perfectly, yes, everyone can file that.
All right, Mr. Ayer, we are learned counsel appearing for the petitioner. Also had Mr. S. Banik, learned counsel, as well as Mr.
M. Islam.
M. Islam, learned counsel representing the private respondents. Mr. P. Nayak, learned SC Finance. Finance Department, Mr. R.K. Talukdar, learned standing counsel appearing for the Accountant General Assam, and Ms. S. Burwa, learned government advocate, are also present. After hearing the submissions of learned counsel for all the parties, it appears that there is scope of amicable settlement of the dispute, whereby the pensionary benefits can be split into 3 parts so as to take care of the needs of the aged mother of the deceased. However, the learned counsel for the contesting parties are paid for 2 weeks' time to seek appropriate instruction from their respective clients and place the same before this court in the form of an affidavit. In view of the above, let these read petitions be listed. How many read petitions? Let these read petitions be listed again after 2 weeks as fixed item.
The interim order in the second petition may continue.
In the second read petition, interim order passed earlier to continue. Give the case number till the next day. Kindly oblige.
Item 47 and 48.
Item 47 and 48, the private respondents have filed affidavit, but state has not filed, although there is a direction.
What had happened in the course of drafting the affidavit, the state government then passed an OM, on the basis based upon Justice Eddie Choudhury's judgment upon reservation and accelerated promotion. A recent OM was published in 2018, this January 18, so that would have a bearing, So we are in the course of drafting and a new affidavit, so it needs some time,
That there may, but my humble submission is that office owner cannot take retrospective effect. Yes, because my promotion, I have challenged the promotion of the respondent.
Now we are concerned with their filing affidavit.
For a short period, because on December, they agreed that they will file a short period.
How much time you want?
A week,
Heard Mr. Esnath, learned counsel for the petitioner, also heard Mr. D. Gogoi, learned standing counsel, Forest Department. PHE Department. Assam will place for 10 days further time to bring the affidavit on record on behalf of the department. They are allowed to list the matter again after 2 weeks.
Item 49.
My lord, pleadings completed. It is otherwise ready for disposal, my lord. It is regarding denial of appointment to the petitioners under the quota of EWS, economically weaker section. Although they have secured higher marks on merit, but final list didn't include their names, saying they have rejected, saying that our certificates of EWS were not proper. At the fact end, they said this. And therefore we said that no, these are proper. It has to be issued on the previous year of the date of application.
We'll have it on 31st as fixed item.
Let it be on first week of March, February, man. First week. 2
February.
2nd February. Yes, second.
Mr. K.K. Mohanto, senior counsel appearing for the petitioner, as well as Mr. T.J. Mohanto, senior counsel appearing for the APC, submit that pleadings have been exchanged and therefore this writ petition can be taken up for disposal. Mr. J.K. Goswami, learned counsel is present.
Respondent 6.
Is present on behalf of the respondent number 6. On the request of learned counsel for both the sides, let this writ petition be listed again on 2023, 2nd February 2023. As for admission as a fixed item.
All right.
Item 50.
May I please, your lordship? This is a case, my lord, where the writ petitioner was attached to another district, my lord, office. In violation of the government rules, my lord. And at the instance of my lord MLA, my lord, of a particular constituency, he requested me, the departmental minister to transfer me out of district. Page 21, my lord, is the request of the MLA. Page 21.
Excuse me. Yes.
And my lord, I have forgone my promotion, my lord, to the UD. I am a junior assistant, my lord, due to the fact that petitioner is suffering from some ailment, my lord, and he is about to retire after within 2 years, my lord, from now, my lord. And my lord, imping order is at page, my lord, 27, my lord, annexure 7, page 27.
Yes.
This is the imping was Sri so and so. office of the undersigned is hereby attached to the office of the Assistant Registrar of Cooperative Societies, Hailakandi, without any public interest, without any requirement, anything, my lord. And so after submission of the, my lord, complaint by the, my lord, Honorable MLA, an inquiry was conducted by the department, Annexure 5, page 24, my lord, in which, my lord, paragraphs 1 and 2, paragraphs, my lord, 2nd and 3rd, my lord, serial number 1, that Sir Sri Dhananjay Das is a person of good behavior. He always working with the public and the staffs cooperatively since my joining to till date. No any complaint found against him. My predecessor also informed me verbally that Sri Dhananjay Das is a well-managed person, and during their period of service at Silchar, they had not received any complaint allegation against him, my lord. These are the inquiry report, my lord, pursuant to the complaint by the MLA and with reference to the, my lord, registered letter, my lord, this inquiry was conducted. Even though, my lord, with the pressure of the MLA, my lord, I was attached to another district, my lord. Without any public interest, no public interest indicated in the order, my lord. And no requirement is there that one person is required, my lord. MLA's letters.
There is a stay order operating.
Yes, madam. 29/9/2020. They have not filed affidavit, my lord. They can file affidavit, my lord.
Ashif, I have the records in this case.
Sure.
Also, the records basically contains the inquiry report that has been annexed with the writ petition, which my learned friend have already placed before your lordship. It is page 24 of the writ petition.
News about it. My lord, recently I come across an order passed by the register saying that, my lord, zonal register has no power to transfer, my lord. Recently, yes, on 18th of January, my. In that view of the matter also, my lord. This is only on 18, my lord. This is also an attachment.
So the inquiry report was also submitted by the same journal.
Yes, my lord. He was authorized to, my lord. To my instruction, my lord, every action was, the attachment order was issued at the behest of MLA only, my lord. Officer was under sore pressure, my lord. He has no option to pass the order. I'm a junior assistant, my lord. Page 21, my lord, the recommendation of the minister, MLA, my lord. The Dhananjay Das, Junior Assistant Officer of the Zonal Joint Register of Cooperative Societies, Silchar Zone. Silchar has been doing many illegal activities. Smooth works of the improvement of implementation for development cooperative society is badly hampered. So you are requested to take transfer from Silchar zone to another zone, Borakbeli to another zone for success of our government mission, madam. Officer of the department saying that, my lord, I don't have any irregularity, my lord, I am performing my duties. MLA has, my lord, some objection, my lord, no, I have to remove my. And the person who has made the complaint, he is not the chairman of that particular society, man. To that effect, my lord, page 23, the chairman of the society informed the joint register that he has unauthorizedly submitted the complaint, man. Page 23.
Why trouble these poor men? MLAs should concentrate on better things. What do you have to say then? All right, heard Mr. J.M.A. Chaudhary, learned counsel appearing for the petitioner. Also heard Mr. G.J. Bordoloi, learned standing counsel. Corporation Department Assam appearing for response numbers 1 to 4. Who is for 5? Notice has been served.
Notice was not issued.
Huh?
Notice was not issued.
Notice was not issued?
Not issued.
Oh. Then too, we cannot dispose of this matter.
My lord.
The stay order will continue, but why notice was not issued earlier?
But he is the MLA, my lord. Some documents were annexed, that is why he was made party, my lord.
Correct, but
I have made party because, my lord, he has, action was taken at his behest. My lord, Honorable 29/9/2020.
no, but we cannot observe anything about the MLA. And if we cannot observe about the MLA, we cannot allow the writ petition.
Not, that is
So
fact.
we can't help it.
Yes, that is.
Then I can't pass any order to the board.
Then, my lord.
Yes, I Mr. J.M.A. so for response numbers 1 to 4. This writ petition is filed against the transfer order dated 26/9/2022, passed by the Zonal Joint Register of Cooperative Societies, Silchar Zone, Silchar, transferring the petitioner.
Attachment, my lord. This is attachment.
Attaching the petitioner to the office of Assistant Register of Cooperative Societies, Hailakandi. First up, the writ petitioner is serving as a junior assistant in the office of Zonal Joint Register Cooperative Societies, Silchar Zone, Silchar. First up, according to the petitioner's counsel, the transfer order has not been issued in public interest, but purely at the behest of the respondent number 5, who is the local MLA, for reasons other than bona fide. Full stop. Mr. G. Bordoloi has produced the records, which in a way substantiates the stand of the petitioner's counsel. However, I find that although there are allegations made against the respondent number 5, and he has been included as a party, no notice has been issued to the said respondent. Full stop. In view of the above, this writ petition cannot be finally disposed of today at this stage of admission hearing. Full stop. Issue notice returnable in 4 weeks. Since the respondent numbers 1 to 4 are already represented, no formal notice is required to be sent to the said respondents. Petitioner to take steps for servicing notice upon the respondent number 4 by registered post with AD. Within
days.
Response number 5, the registered post will be ready within 3 days from today. Uh, the records be retained by the learned departmental council to be produced on the next date fixed. Interim order passed earlier to continue until further order.
Obliged.
Okay, as per last order, they are supposed to file affidavit.
Yes, who is there in this?
Lordship, may kindly take up the matter after some time, my lord. My senior Dina is.
Why it has come up today?
What it will fix, madam?
So we'll fix another date then.
My lord.
And go on fixing dates. Why it has been listed? It may be fixed, but what is to be done today?
Lordship, I have sent the lordship to advertisement, lordship.
There is some direction to file affidavit.
Yes.
Lordship, may kindly give us some time, lordship.
Mr.
Is it, lordship?
A.Z. Ahmed, learned counsel is present on the petitioner. His MD Bora learned government advocate Assam
My lord.
submits that the affidavit in terms of the order dated 19/12/2022 could not be filed. And therefore, 4 weeks further time be granted for doing the needful.
By humble submission, lordship. In the meantime, some petitioners were appointed, lordship. Can they stay their appointment, lordship? Yes, there is already stay, lordship.
No. Prayer alone. Let this writ petition be listed again after 4 weeks. Interim order passed earlier to continue. It is, however, made clear that appointment, if any, made during the pendency of the writ petition and not covered by the interim order shall be subject to further orders that may be passed in this writ petition.
My lord. Lordship, G. Assam may be repeated in the cause list.
Let this writ petition be listed again by reflecting the name of learned G. Assam in the
My
cause
lord.
list.
I am deeply obliged.
May I please your lordship? Lordship, the impugn order is at page 59, lordship, and the operative part is page 61, lordship. Lordship, these penalties has been imposed to the petitioner without charge sheet and also without giving an opportunity of hearing and cross-examining, lordship. Moreover, no inquiry report was also submitted to the petitioner, lordship. And on the last occasion, the respondents were supposed to file their affidavit, lordship, but notice issue was.
Lordship, some penalties were imposed upon the petitioner. On appeal, lordship, some of them were reduced, lordship.
Only the demotion part has been reduced.
Yes,
Yeah.
lordship, this is the second time this matter has been listed, lordship. So I'm praying for some time to find my affidavit, instruction.
Because it is second time.
No, it's a very new matter, lordship. I have already asked for instruction.
Lordship, a date may be fixed, lordship.
All right. Heard Miss
Bibi Hussain, lordship.
Hussain, Nayak counsel for the petitioner. Also heard Mr. P. Nayak, learned standing counsel PWD Assam, who submits that another 4 weeks time is required to obtain instruction and file affidavit. Considering the nature of issues involved in this proceeding, this court is inclined to grant time to the learned departmental counsel as prayed for. Therefore, registry is directed to list this matter again after 4 weeks as a fixed item. In the meantime, affidavit on behalf of the department be brought on record.
Lordship, one more prayer, lordship. Item number 31 is a time being matter, lordship. I'm hearing from PW itself. Lordship, in this matter, direction was issued to produce the record. Affidavit we have already filed. That is coming from Majuli, lordship. Within 2 or 3 days, lordship, we are going to get this record.
In item
31.
31, Mr. A.R. Bhuya, learned counsel for the petitioner. Mr. P. Nayak, learned standing counsel PWD submit that the affidavit will be filed with the.
It has already been filed. Lordship, call for
filed and the record are on the way, and therefore this matter will be posted again in the next week. In view of the above, registry to list this case again on 1/2/2023 for admission. 1st February.
Orders item 53.
Wednesday.
Made business election. This is that 454 matter, Companies Act, where the official liquidator has already submitted a report of dissolution, my lord. But I don't know subject, what I'm thinking, my lord, because the report of the OL is for dissolution of the company because of no funds and no assets. And this is filed in the in this miscellaneous company application that we have filed under section 454 of the Companies Act. Now, based on that, if your lordship have to pass the final order of dissolution, that has to be passed in the main case, which already has been disposed of in the winding up. So I was thinking maybe, my lord, we should come up with an IA, and then it would be convenient for your lordship to pass that order.
Mr. K. Goswami, learned senior counsel appearing to the OLs, submits that although due process has been completed in this case, yet an IA is required to be filed, bringing on record the steps taken in the meantime. On such grounds, Mr. Goswami has prayed for posting this matter after the IA is filed. Prayer allowed, list the case accordingly.
Deeply obliged.
List the cases accordingly, 53 and 54. Yes, what is this matter?
Very clear. The review in relation to the judgment and declared 22/9/15 is 99.
Page 99.
Page 99. On the case matter, the advocate, learned counsel for the respondent was absent. The matter was heard and finally decided against the matter respondents.
Who is appearing for the respondent here?
Notice was not issued for us.
Why? What is the review you are seeking?
So far, the transfer of the property is concerned. It was basically an issue as land matter.
Change করবো।
In the year 1954, my lord, the land was transferred to one my lord. In the year 1954, land was transferred to one Ratneshwar Taluka.
This order was passed in a second appeal, is it?
My lord.
And this is the order of 2015.
15.
And
We have
when
filed it on in the year 2018. Delay was not a condone, my lord.
delay was?
Condone.
So delay was condoned after hearing other side? No.
My lord, I have actually.
Where is the order? Where is the order condoning the delay? Mistake was in here.
Notice service.
So which part is objectionable according to you?
my lord, so far, my lord, transfer of the land is concerned, my lord. My lord, it was in the year 1954, before coming into existence of the Assam state acquisition of land belonging to religious and charitable institutions of public national act. It was coming to effect in the year 1961. Prior to that, my lord.
We'll issue notice at this stage. I heard Mr.
M.K. Sharma.
M.K. Sharma, Learned Counsel for the review petitioner, peruse the order dated 22/9/2015, passed by this court in RSA number 29 of 2007. Issue notice returnable in 8 weeks. Petitioner to take steps by registered post with AD for service of notice upon the respondents.
Highly available.
May it please your honor. The lordship, by the last order, lordship, the department was supposed to place the records of the departmental proceeding. Lordship, may I pray for further 2 weeks' time, lordship? I have not received the.
You are appearing for the petitioner.
Yes.
He wants 2 weeks further time.
Okay.
Your name, please?
Dipali Dutta.
Ms. Dipali Dutta, Learned Counsel is present on behalf of the petitioner. Mr. D. Upamanyu, Learned Standing Counsel, Health Department, Assam, prays for and is granted 3 weeks further time to produce the record as called for by the record of the disciplinary proceeding as called for by this court. Let the matter be listed accordingly.
Highly obliged.
Item 57.
As per the last order date 12/12/2022, there was a submission made by the party applicant that talk of compromise is going on between the parties. Liquidation is on and notice was issued to the liquidator. The company is on liquidation. So he wants further time.
Well, lordship, the matter may be taken up at 2, your lordship. My senior is on his way, your lordship.
Who is your senior?
M. Sharma, your lordship. Mr. M. Sharma.
All right, we'll take it up at 2. Yes.
Much obliged.
Item 58.
Lordship, as per the office note, pro forma respond number 7, the AD card has neither returned nor been served. Actually, as per my instructions received from my clients, he received a call from the pro forma respond number 7 that they have actually received a copy of the writ petition. But somehow, your lordship, the matter is still coming up for order. So they have actually received the writ petition. That's what's my instruction goes, your lordship.
What is it? You are not appearing for respond number 7.
No.
No, lordship.
Why?
They are state government entity, pro forma respond. They are actually pro forma party because they are not necessary party. The necessary party is for 1 to 6 because.
Maybe, but notice has been issued.
Yes, your lordship, that is the problem. Somehow the AD card did not actually return back.
So this telephonic thing will not do.
I understand. I understand.
Heard Mr. D. Bora, Learned Counsel, appearing for the petitioner. Also heard Ms. B. Sharma, Learned CGC, appearing for respond numbers 1 to 6. Full stop. This matter could not proceed further on the ground of non-service of notice upon the pro forma respond number 7. Full stop. According to office note dated 8/12/2022, the petitioner was required to take fresh steps for service of notice upon respond number 7. Have you taken that step?
No, your lordship, I have not taken.
But Mr. Bora submits that
I'll take.
steps could not be taken till today. Hence, he prays for 7 days further time to take steps as per the order dated 8/12/2022. Prayer allowed. Let the matter be listed accordingly. Yes. It matter ICC to call go. Yes, Mr. Sharma, you be here. We'll call up your matter. You are not present.
Well, the matter relates to the consideration of promotion of the this petitioner, Malak. And below the petitioners, some of the respondent number 4 and 5, they have been considered for promotion. And since
the date of joining has been mistaken by the respondent authority. Instead of 13-9, they have given 31-9. So because of this, my lord, some of the private respondents have been promoted. So I have come before Lordships, and Lordship has considered all this matter, and after being consideration, the interim order was passed by this honorable court. And it was found that yes, this petitioner was actually his date of joining was 31/2009. But in the gradation, the list has been prepared, gradation list has been prepared, that is 31/1/2009. That is why I'm like of course now my brother has.
My lord, let this matter may come after 10 days. I have advised my client, my lord. We already, my lord, department is working on it. Respondent number 4, my lord, has forgone her promotion, my lord. She doesn't want to take it. And yes, we accept it, my lord. There are some wrong, my lord. Typo or whatever, my lord, inadvertent wrong. So, my lord, we are working on it. What I want is, my lord, next day my senior friend should come and say that the matter has become infructuous. We are working on that, my lord. I have advised my client, my lord.
Mr. B. Chowdhury, learned counsel is present under the petitioner. Mr. R. Dhar, learned standing counsel, WPT and BC Assam, submits that the issues raised in the writ petition is being minutely examined by the departmental authorities to figure out as to whether the claim of the petitioner can be addressed suitably, and therefore 2 weeks further time is required for bringing the process to its logical end. On the request of Mr. Dhar, registry is directed to list this matter again on 8/2/2023 as a fixed item. On the next date fixed, the learned departmental counsel to place relevant instructions before this court.
Okay.
Pending matter item 57.
In this case, that some compromise proposal is being filed by the miscellaneous IA applicant, Jalan Nagar Tea. So that was pending before the bank, and only yesterday I have received the instructions that has been that they are directed to pay 3 crores. So a short period may be given to me, your lordship.
Mr. M. Sharma, learned counsel for the applicant. You are for the applicant.
Applicant HDFC Bank Limited in the main case.
Learned counsel for the HDFC Bank Limited prays for further 4 weeks time to conclude the process of out of court settlement which has already been initiated in the matter. Mr. S. Biswas, learned counsel appearing for the
Respondent.
Respondent is present and does not have any objection to the prayer is allowed. In view of the above, let this matter be listed again after 4 weeks along with IA. This IA is yours.
No, this IA has been filed by Jalan Nagar. Your lordship.
Along with the pending IA. Yes, next matter. Yes. You're in the hearing case. What is the matter about?
Lordship, this is a disciplinary proceeding matter. Lordship. If it can be taken up on Tuesday, Lordship, I am slightly finding it difficult.
Tuesday means next Tuesday.
Next Tuesday, Lordship. Otherwise, I am ready, but your Lordship, due to CAF, your Lordship,
You are there.
Yes, your lordship, for bank.
Item 50, you write, Mr. S. Bothakur, learned counsel submits that although this matter has been fixed for final hearing today, he is suffering from the throat infection and therefore is unable to argue the matter. On such ground, a prayer has been made to fix this matter again on 31/1/2023. Mr. M. Sharma, learned counsel appearing to the respondents, does not have any objection if the prayer is allowed. As such, it is directed that this matter be listed again on 31/1/2023.
Deeply.
Are you supplementary?
But here I was directed to produce the records, pertaining to the selection. I have received some records from the SP, but from the state level recruitment board, some records I am awaiting. But I pray that may be taken on 3rd of February. On 3rd of February.
You want 3rd of
But last occasion also this type of prayer
No,
was made before.
the records from SP I have received. This I can.
That was the position on earlier occasion also.
Yes, yes. No. SP I have received recently. We have filed.
What is the, which order has been violated?
Well, the order was dated, my lord,
No, what will you do with the record? You file your affidavit.
affidavit is in file.
Has the order of the court been complied with? It's a contempt case.
Yes, my lord.
Which
Contempt-
order?
Contempt as well as the repetition.
Order at page 10, my lord.
Order at page 10. So petitioner was asked to be allowed to participate in the selection process.
It's a conditional order, last
And
paragraph, my lord.
his outcome is to be kept in a seal cover.
Well, the condition was that if the process is not over till then, it was on 10th of November, the order was passed. We have filed the affidavit, we have stated in the last paragraph, kindly see that the participation of the petitioner in the recruitment process, however, will not waste any right till outcome and recruitment process subject to the condition that the other aspects of the so and so, and if the process is not over, then he should be allowed. But on 6th of November, the process is over. But it started on 20th of October. On 20th of October, he filed an application for rescheduling the date. It was fixed on 27th of October. It was on 27th, he again filed an application for rescheduling the date. But those records are there in the SP's instruction.
Let him get the complete record.
Right.
What else can be done? We'll see whether there is a contempt or there is.
I'm not against the current report, my lord. The first time this prayer has been made, that is state report not found. Same was the
No,
condition today also.
record I have not received.
That
In-
is
in
the
fact-
position today also, my lord, though it should not be lingered, my lord. That is.
I had heard Mr. Emesher, learned counsel appearing for the petitioner in both these cases. Also heard Mr. D. Nath, learned counsel appearing for the respondents, who submits that the affidavit on behalf of his client has already been filed. And additional records called for from the office of the SP.
The recruitment board.
SP of the recruitment board.
No, but the SP from Nalbari SP I have received. From the state level recruitment
SP
board.
Nalbari district has already been received. However, some records from the
State level recruitment board
are still awaited.
Right.
According to Mr. Nath, these records will unequivocally go to show that there has been no violation of the court
Yes.
order. Mr. Sheikh, on the other hand, has refuted such submission and contends that the authorities have deliberately violated the order of this court. Be that as it may, in view of the prayer made by Mr. Nath, these matters are directed to be posted again on 3rd February 2023 as fixed item. On the next date fixed, all records be positively placed before this court so as to decide on the question of maintainability of these contempt cases.
Hold on. The records received so far, I'll take them. The records
Yes, you
received.
take that.
I'll take. Hold on.
What is this contempt?
This year the amount was supposed to pay by the respondent and along with the interest also. And it has not been paid seriously.
Where is the order?
Lordship. Starting from page 18, Lordship. The paragraph number 20.
Lordship, we have calculated it, and Lordship, all the necessary arrangements are being done. Lordship, it will be paid very soon, Lordship.
All right, how much time you want? 3 weeks further time to comply with the court order. Have Mr. D. Kalita. J. Kalita and counsel for the petitioner also heard Mr.
SM Hassan.
SM Hassan, learned counsel appearing for the
Respond number 1.
respond number 1, who submits that necessary steps for compliance with the court order has already been initiated, and within a short time, the necessary disbursement will be made to the petitioner. You are appearing?
Respond number 3.
Achha. Mr. R. Rafiq is present on behalf of.
R. Ahmed.
R. Ahmed is present on behalf of respond number 3. Taking note of the submission of Mr. Hassan, this matter is directed to be listed again after 3 weeks so as to enable the respondents to comply with the court order. All right, so any matter, anybody is willing to do a final hearing case?
After hearing, civil bench case. Okay, 1 to 10.